Coussant is going to lead us in the Pledge of Allegiance.
Good morning. Good morning. Y'all all back, man. Y'all back? Okay, let's pray. Our Father, our God, thank you for another opportunity to come before the public and to serve our fellow citizens. We just ask your blessings upon this work that we do here today. As you look down on us, we pray that it'll please you in all our words and what we do and how we treat our fellow citizens. In Jesus' name we pray. Amen.
Amen.
Pledge of allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Good morning, everyone. Any announcements from the commissioners? Commissioner Lewis?
Thank you, Mr. Chairman. The first thing I want to do is acknowledge a dear friend of mine who has sadly left us, State Senator Larry Selders. Larry was not only my state rep, he was also my state senator and a close friend of mine who tragically, suddenly passed away earlier last month. Senator Selders was the epitome of a public servant, a person who I think had no enemies and found a way to be helpful and joyous. I'll never forget when we had a constituent call our office about 3 years ago on an issue that we had never heard of and the commission had never heard of around apartment complexes not giving tenants their utility bills. It was in Senator Selders' district. I called him, and right away he agreed to file a piece of legislation for this commission, and it ushered it through the legislature. And so his commitment to the people here in Baton Rouge, to the people of Louisiana, and to his friends and family is left unknown. And so I could not let this meeting attend without thanking him for his service and the job well done that he did on this earth. Next, Mr. Chairman, the only other announcement I have is at the summer meeting at NARUC in Minneapolis, the Consumer and Public Interest Committee, which I vice chair, along with the Water Committee, passed a resolution from NARUC that would call on Congress to refund the LIWAP program. The LIWAP program was an assistance program for water assistance for people to pay their water bills that was funded during the COVID and through the rescue plan. Unfortunately, that has not been renewed. And as we have had multiple conversations here at this commission around water, wastewater, and the challenges of affordability, that resolution highlights the need to have a federally funded program such as LAHEAP that helps on the electric and gas side there. So I would encourage all of our water utilities to take that resolution from NARUC and talk to our congressional delegation to encourage them that they've finally passed a LIWAP program that will bring assistance for those who are struggling with their water bills. And with that, Mr. Chairman, that's all the announcements that I have.
Great, thank you. Any other announcements?
We do have a couple of legislators in the audience. I'd like to welcome back Stephanie Hilferty, representative, who also is running for Public Service Commission. So I want to welcome Stephanie. And I think I saw, do I have Representative Billings? Representative, nice to see you here at our meeting. We always invite our legislators. We love to see y'all here so you can see and hear what we're doing over here to work together with you to move the state forward on our utilities. Mr. Chairman?
Anything from,
Mr. Chairman, I've heard.
want to use your microphone, sir?
I've heard through the grapevine that Commissioner Campbell's on the mends. Yep. And I want to send him a message. He's in my personal prayers. I hope he's in yours too. I kind of miss the guy, and it's been a good balance between us on each end. But come on back soon, Commissioner Campbell. We miss you.
Well, you took one of my announcements away. So the next one is just a reminder that the October meeting will be held in New Orleans, Louisiana. It is going to be at the State Supreme Court building. That'll be Thursday, October 22nd, I believe. It has been finalized and confirmed that it will be there. Further information will be announced at the September meeting about other issues.
And one other announcement too, kind of along those same lines with Commissioner Campbell, we are going to have the December meeting in Shreveport, location to be determined, but likely the city council chambers, which is where we've traditionally held it up there.
Okay.
And I'll echo what Commissioner Francis said. After my conversations with Foster, I'm surprised he didn't sneak in here. I think efforts were being made, so Foster, if you're watching, but I would fully expect him to be here in September.
All right, thank you very much. I'd like to go on. Anything else from you before we move to the announcements on the agenda?
Yes, sir, I do have one. So I do have an announcement related to the Energy Efficiency Working Group. The first meeting, the public meeting, will be scheduled for Wednesday, September the 23rd, here in the Natchez Room, beginning at 9:30 a.m. And for those interested in participating, please email me no later than September the 2nd so that I can have a head count and send a proposed agenda out prior to that meeting. So that's Wednesday, September the 23rd, here in the Natchez Room, and get with me before September the 2nd.
Okay. Commissioner Francis?
One other announcement. I want to welcome some of my hometown crew, the mayor and several of the city council from the great city of Crowley are here. Where are you at? Raise your hand here. Yeah, welcome to the meeting here.
Great. Would like to also announce there's been a ruling at the Fifth Circuit which has struck down the, as identified as illegal Biden-era energy efficiency standards for stoves and cooktops for the nation. So that'll be moving on to the Supreme Court for final decision. So that was something that we worked on with the National Gas Infrastructure Task Force for about 2 years before it was taken up by Louisiana as well as several other states. So why don't we go through the agenda? I know we're going to move 2 items to the front, and if there's any other issues.
Yes, sir. So and technically 3 items.
Okay.
So first is going to be Exhibit 20. And then after Exhibit 20, we will take up Exhibits 28 and 29.
So 20 is going to be first, 28.
And 29.
Second and third. Okay, go ahead and do the in-ray on 20, and we'll begin.
So exhibit number 20 is docket number U37882. This is Entergy Louisiana's application for certification of generation and transmission resources and for other relief. It's a discussion and possible vote on Meta's platform motion for immediate review of interlocutory ruling. In its application, Entergy sought the Commission's approval to add approximately 5,200 megawatts of generation in addition to battery storage and transmission to serve eVest. According to the application, eVest is locating a large hyperscale data center in Richland Parish adjacent to the facility approved in Commission Order Number U37425. On June 29th of this year, interveners, the Alliance for Affordable Energy, and the Union of Concerned Scientists filed a motion for subpoena for the production of documents directed towards Meta, which is not a party to the proceeding. The motion for subpoena was opposed by Entergy and Commission staff. After hearing oral argument on July 8th of this year, the administrative law judge issued a ruling on that motion for subpoena on July 10th, and the subpoena ruling denied in part and granted in part the motion. Specifically, the following documents requests were granted for Meta to supply: analysis, data, reports, calculations, and/or evidence which demonstrate the level of investment in permanent job creation expected to be entailed by the Richland Data Center, and analysis, data, reports, calculations, and/or evidence which substantiate the amount of electricity load the Richland Data Center will need. On July 14th, Meta filed a limited appearance in the docket to challenge the subpoena ruling. At issue herein is Meta's motion for immediate review of the interlocutory ruling pursuant to Commission Rule 57. After considering the memorandum and arguments of the parties and in accordance with the procedures set forth in Rule 57, the ALJ declined to reconsider the interlocutory ruling and referred for the Commissioner's immediate review of the subpoena ruling. As this is a request for review of an interlocutory ruling, there is no recommendation from staff.
The chairman moves to defer this matter to September based on the fact that there are 3 other interlocutory issues that are all going to be decided at once regarding this particular case. So we're going to take this matter up in September along with the other issues, but I understand there are people here today who have put cards.
And Mr. Chairman, I'm sorry.
Hang on a second, I'm not finished. That I know we have yellow cards, and if they want to make comments, what I'd like to do is limit the comments to 3 minutes each, and also I want to make sure that we don't double cover comments. So if you want to make comments about the deferral till next month, that's fine. But we want to try and keep it on that because that's the issue today. So if you'd like to, have you gone through this yet?
Do you want to call up 3 and then have 3?
Yeah, that's fine. And if you've already identified the folks and what they're going to do, but like I said, be respectful about this. Keep it on the issue about the deferral, and then we'll go from there. And then I'm going to turn this over to Commissioner Lewis.
Thank you, Mr. Chairman. I would like to stage my objection, and I will object to the pending motion to defer.
Sure.
I would like to say, before we get to the public comment, exactly why I am opposing this motion to delay this proceeding. As according to our rules, the Meta has asked for immediate review of their subpoena ruling, and I believe time is of the essence. We have made arguments that this is the time, and so I do have questions when we suggest that the motion to quash and the motion for immediate review are considered together. These are separate issues that we should take separately, and if Meta files another motion for immediate review of the quash, we can handle that when they such do file it. Just for procedural records, let's be very clear on how we got to this moment. The administrative law judge on July 14th ruled that the motion that the NPOs had filed on a subpoena should be stayed until they could make their interlocutory review. On July 14th, he also asked them for comments and review. On July 27th, Meta responded to the briefs that our staff and the NPOs filed, and on July 29th, there were oral arguments. On July 16th, the administrative law judge asked us whether the motion to quash and the motion for immediate review should remain distinct for the purposes of the record of appeal. And when that question was responded to all, this is what the parties in that case said. On July 24th, the NPOs responded, and I quote them from their citing on page 17, the motion to quash and the motion for immediate review should remain distinct for the purposes of any record on appeal. While there is some overlap between the motions, Meta does raise some specific contentions in the motion to quash that are not included in the motion for immediate review. More, there are issues in the motion for immediate review that do not appear in the motion to quash. Subsequently, the staff of the commission stated, and I quote them directly, as explained, the motion to quash and the motion for review serve different procedural functions and are governed by different standards. The motion to quash and the motion for review should remain distinct unless a party, including a specific purpose party, Meta, specifically requests that they be combined for the purposes of appellate review. Meta was asked that exact same question, and Meta in their briefing said, the two motions remain distinct for the purpose of the record on appeal because they are two procedurally distinct motions. They said the motion for reconsideration either withdraw or modify the subpoena, but the discussion of legal issues between the two motions overlap, but the motion to quash asked the tribunal to evaluate the subpoena and vacate it, while the motion for immediate review requests the commission to evaluate the tribune's decision to issue a subpoena under that ruling, reverse it, or vacate the subpoena. And when we got to the trial, the question was asked to Mr. Adams, who was representing Meta at the trial, whether or not these two distinct motions should be combined. And he said, Your Honor, you asked about the effects of denying the motion to quash. What would that have on the motion for immediate review? I think it would have no effect on the motion for immediate review. Those are different things. The motions basically, the motion to quash is challenging the substantive validity of the subpoena, while the motion for immediate review is addressing irreparable injury and a review. So I think it has no effect on the motion to quash if it is denied, and it would have no effect on the motion for immediate review that would stand. The motion for immediate review stand, and the judge on last Thursday ruled that the motion to quash was denied. Meta did not file a request for immediate review until 4:38 p.m. yesterday. They had time to ask for immediate review for us to take them up, but based off of the parties in this case, they have made it very clear in their briefs and in the hearing that we should see these two motions very separately. And I would say the commission voted to fast track this process with the Lightning Initiative at Entergy's request. And speed can not only be used when it values Entergy and Meta. They don't get to dictate our commission proceedings. We exercised our own rule in 57 and pulled the jurisdiction of this case from the ALJ without a recommendation from the trial. So having made that choice, deferring now means we're also kind of reversing our own procedural decision at another request by Entergy and Meta. As you see, I've read the briefs, I've attended the hearing, I've looked at the parties' request, and I am prepared to handle the question at hand. We cannot consider this as a delay tactic, and I'm fearful that it is. Because if we go back to the prior proceeding, the prior subpoena, and the subpoenaing was quashed specifically because of its proximity to the hearing. And the ALJ distinguished this subpoena because it was filed months in advance. However, if we delay, we risk handing Entergy and Meta the same legal arguments to quash the subpoena before the October trial. And so I think it is important that we look at this and we realize that we should take up the matter as requested in immediate form. We have found a way at this commission, for some odd reason, to find every excuse to not do something when it favors Entergy and Meta, but we find every exception to our rules when it favors Entergy and Meta, and that's why I oppose the motion to defer, and I'm ready to vote on the issue at hand. Thank you, Mr. Chairman.
Sure, thank you very much.
Mr. Chairman?
Look, I appreciate the applause and everything. We've got to move through this, so try to constrict it if you can, okay? So, like I said, I understand. We're trying to get a little information from council on this for a second.
Mr. Chairman?
Yes, sir.
I tend to agree with Commissioner Lewis that we should take this up today. So I've asked staff to basically review the posture of the matter and tell us the actual motion that would be on the table.
Right. And Lauren, can you take and have a private moment with Commissioner Kusan and to talk about this, see about legal procedure on this?
Okay.
It's okay? So what we
Yep.
discussed? Or you want to go talk?
Would you, so, first of all, from our general counsel standpoint, Executive Counsel, could you tell us the posture of the matter? And Commissioner Lewis wants us to take it up today. What would we be taking up today, should we move forward and not ask for a second to move this matter to September?
Sure. So what is in front of you today is Meta's request for an interlocutory ruling on our ALJ's ruling to issue a subpoena to Meta for the specific information I read into the record earlier. So it's you guys' review of an ALJ ruling that a subpoena should be issued to Meta in this docket. And that's the only thing that is in front of you today.
And so our question before the commission would be whether or not to agree with the ALJ's ruling to issue a subpoena for a portion of the information that was requested.
Correct. You would be either agreeing with the ALJ's ruling to issue the subpoena or disagreeing with the ALJ's ruling to issue a subpoena.
And I would like the language to make a motion to disagree with the ALJ's ruling. That's the language that I'm looking for, just to air it
Right.
publicly. That's the language that I would like to make very clear so that we have a clear understanding of what we're voting on today.
And the second issue that I wanted to ask about is in the next month, since we're going to have this again on the motion, we have something else in September about the motion to quash?
Possibly. At this point, Meta has also filed a request for interlocutory ruling on a separate judge ruling on a motion to quash. She denied Meta's motion to quash.
Is that motion to quash subject to approval by the commission at this point?
Yes. Well,
Okay.
not today. It is subject to your approval in September. It is not
So it's not ripe yet?
correct.
Okay. So that is not subject to a ruling today?
Correct.
Okay,
It is solely
so-
the issuance of the subpoena.
Got it? So do you have a motion
Ms.
that you
Evans
could
got it.
provide at this moment to put on the floor?
Lauren Evans on behalf of staff. Yes, sir.
Wait, I'm
Mr.
sorry,
Chairman,
before we,
just for clarity, are we pulling the motion to defer?
We
Well, that's
haven't
what-
even.
Because if we're putting a motion on the table,
Well,
we'd
it
have
could
to
be,
just
it'll be a
clarify.
substitute motion.
Oh, okay,
So
I just
hang
want to
on.
know
Yeah.
what motion we're
And we
putting on the
haven't done
table.
anything yet. So I'm asking if you have something prepared, Lauren, that you could provide for a motion a substitute motion to oppose and reject the ALJ's order and quash the subpoena.
Yes, sir. So the motion would be, I move to reverse the tribunal's ruling
This will come from Commissioner Kusan.
and vacate the subpoena, rendering the motion to quash moot.
And
That's
Chair will second it.
that's my substitute motion that I'd like to put on the floor.
And Mr. Chairman,
And
for
Chair-
clarity, I will remove, since that's your motion, I will remove my objection to the deferral, so that can be the standing motion, so it won't have to be a substitute.
There you go. And so I will withdraw my motion to defer. I will second Commissioner Kusan's motion.
And I will object to Commissioner Kusan's
There
motion.
you go. Now we have witnesses, and it'll be on the motion to quash, a motion to overturn the ALJ's ruling, so they can comment.
So the comments today will be related to the judge issuing a subpoena to Meta for specific information. So the comments should all be limited solely to whether a subpoena should be issued to Meta in this docket.
Correct.
Okay. I just wanted to make sure
Right,
everyone else is.
and what I'd like for you to do, Catherine, is, act as referee to restrict the comments and try to keep it on track at least. And like I said, we want to keep the comments to 3 minutes. How many witnesses are we going to have on this? Have you identified?
A decent amount, I haven't counted them, about 20.
I think we're going to have to try and see if this is going to be repetitive, and we may have to find a number to where we'll have to, stop
So, yeah,
this.
so you could instruct limit of time of 3 minutes strictly to whether the subpoena should be issued, and if the comments have already been made by a prior public person, to limit those comments.
Okay, well, let's try to do that so we're just not like grinding time for the same stuff over and over again.
Yes, sir.
We certainly want to have comments, but, I mean, we don't want it to just be an abusive process, that's all. So go ahead and I'll let you be the referee on this.
And while she's doing that, we did get some comments submitted electronically, and kind of to your point,
We can
some
put
of-
those into the record.
We will, but some of those are generic. They're not restricted. I saw one, for example, saying, I live in Rapides Parish and I don't want a data center here.
Okay, well,
that's
not
obviously this
associative to the
matter.
record,
So,
right.
Yeah, okay.
Okay, well, like I said, Colby, you be the timekeeper, Catherine, you be the referee, and we'll go ahead and hear the comments. So start stacking them here, 3 and 3, and then we'll move through it.
Would you like
Yeah,
3? Okay.
put 3 in the bullpen and 3 in the chairs.
Okay. So Ms. Susan Stevens Miller and Ms. Logan Burke for the Alliance for Affordable Energy, and a Ms., is it Osti Robbins? I'm sorry if I did not pronounce that correctly. Power Coalition for Equity Justice. The 3 of you can go to the table. And then a Joseph Ruzeneg with Louisiana Workers Council, Gabrielle Gemma, Louisiana's Workers Council, and Ms. Deborah Perlman with the Party for Socialism and Libertarianism and Take Back the Power campaign. There are 3 chairs right here if the 3 would like to come sit up. Yeah, and just for the record, well, you signed the card, so never mind. You're good.
You ready?
Bring it as close to you as you can, the microphone, and I'll try to, if you're testifying in the front, please bring the microphone as close to your mouth as you can. Otherwise, you can't hear it online, and we can't hear, because I can't hear.
Thank you. My name is Susan Stevens Miller, and I represent the
We'd have to
Alliance.
bring it closer.
Even closer?
It does have
Okay.
to be pretty
Okay.
adjacent to you.
My name is Susan Stevens Miller, and I represent the Alliance for Affordable Energy and the Union of Concerned Scientists. We are the parties that filed the motion for subpoena, and we request you reject the motion that was recently announced. Essentially, it's important to recognize that this has been a 2-step process. The first process was just to see if the subpoena should be issued. It is important to note that the ALJ was very careful. We asked for 5 categories of information and only got 2. The ALJ very carefully analyzed what was requested and why, and found that only 2 aspects, economic development and the actual load that Meta will need, should be provided. And it's also important to note that Meta did not participate at this stage in the process, though it could have. When we filed our motion for subpoena, we served their resident agent. So they knew the subpoena was there and could have participated in this part of the process and did not. It's our contention that they don't even have standing to bring this specific motion because they're not a party and the rules say parties, and they chose not to participate as a non-party. So it's important finally to note why this information is necessary. With regard to economic development, the ALJ relied on the Governor's EO 26058 and your lightning directive and determined that this is a special case, that economic development is a high priority. It is actually the only public interest that Entergy claims exists in this proceeding is the economic development. So, and all we asked for was information with regard to that economic development. How many actual jobs? How many permanent jobs? How many remote jobs? That's the information we were looking for because that's what they claim is in the public interest. The second is the load. The load is what supports their request for 7 generating stations. Now, we have argued in our testimony that you should not approve all 7 at once. It's difficult for anyone to argue against the generating stations without knowing what Meta's load actually is and how they developed it. Entergy is asking for over $13 billion of infrastructure just for this part of the data center. And I think at the very least, and as the ALJ noted, it's a 2-step process to determine if generating stations should be built. And one of the steps is missing in this case. And that's the information that will be provided, and that's the information that's necessary to decide if this application should move forward.
Hi there. Logan Burke for the Alliance for Affordable Energy. Thank you for the opportunity to speak today. The point that I would like to make is that this Public Service Commission has the jurisdiction to make decisions that no one else in the state does as it relates to the public interest. And as Susan pointed out, Entergy and indeed the governor and many other elected officials have insisted that the public interest is met in large part because of the economic development elements of this case. It's incredibly important that the very last people who have an opportunity to say whether this is in the public interest has the information to make that determination. As it relates to the load and how the power is going to be used, this industry is so nascent, and the way in which the power is used in these facilities is so different from the ways in which industry has used power for decades, that the industry is really just now trying to figure out exactly how to make sure that the system stays reliable. FERC is looking at this, MISO is looking at this, and the way in which the power is going to be used and how much is going to be used will also determine how reliable our grid stays, especially in North Louisiana. And so that information is incredibly important to the public interest. Kicking this down the line and waiting for this information only means that other parties in the proceeding, like the Alliance and others, won't be able to fully represent our case, and that this commission won't have the necessary information to make a good, informed decision. I really appreciate the opportunity. Thank you.
Can I ask a question? Well, go ahead. I'll ask after you're done. Thank you.
Good morning. I'm Aste Davis Robbins with the Power Coalition for Equity and Justice. I just want to echo what these ladies have said, but also say that Louisianans are literally learning about these data centers day by day, bit by bit, article by article. They're learning about NDAs and private deals, property sales that they don't know about, as well as insider trading rumors. So this is the chance, the one true chance of transparency that lies within your hands, along with their own leaders making these decisions blindly for them. We're sitting on the sidelines waiting to learn of the environmental impacts that this will have, while also watching our brethren in neighboring states endure these impacts. So I feel that Louisianans need to know this information. We stand before you with a plea that the least you can do is vote for transparency today. The judge has already determined what should be done, and we don't think that you should be overturning what the judge has decided. Set the precedent that people deserve to know, set the standard that you protect the voters that seated you, and set the moral paradigm that even if you support the project's build out, that you congruently support your state, districts, and own people. Thank you.
Okay, thank you. Is this, can I ask you, you're a lawyer?
Yes, sir.
Is some of this information accessible to you as confidential for lawyer's eye only type of information?
If they provide it, it will be accessible to me. I'm assuming that all that is provided will be provided on a confidential basis. So only certain people who've signed the NDA and are approved will be able to see it. It will be labeled confidential. But we will be able to use that information in the hearings, which include confidential information when you argue in the hearings.
So are you arguing, I'm just asking for your purposes, are you saying that is still not enough with and because I know the distinction between the two of you is you're a lawyer and she's not a lawyer, but so you have access to the information that would be provided?
If it's provided, I will have access to the information.
Is your argument going a step further and saying that you want it even more accessible than even beyond lawyers? Or can you clarify that for me?
Yeah, there is another motion that will be before you next month that is called Attorney's Eyes Only motion. That was our motion to allow Logan and our other client representative to see the information, which thus far Entergy has denied that they see it. At this point, our experts can see it, our attorneys can see it. Essentially, there are only 10 people involved in the case who can't see the information, and 8 of them work for either the Alliance or the Union of Concerned Scientists. So we think that's unreasonable, but that's actually not before you today. That will presumably be before you in the September hearing. But If that doesn't stand and if you overrule the ALJ on that issue and find that Logan and the other representatives can't see that information, then the other 50 people who are involved in the case, the experts, the attorneys, and people like that, will be able to see the meta information, but the 10 people who have been denied access to the information will not be allowed to see it.
Okay. But I appreciate that clarification. Thank you.
We'll move on to the next three, please.
But wait, I
He's got
got
some
something
questions.
also.
Got a long way to go.
From what I'm hearing you need two questions answered. One about economic development, one about how much electricity. Have you talked to the governor and the economic development people, Susan Bourgeois? Asked them these questions? Looks to me like that's where the answer would be on economic development questions.
My understanding is they don't have that specific information either, because Meta hasn't provided it to them either. They don't have the specific information with regard to, yes, there will be this number of permanent jobs. Yes, there will be this number of part-time jobs versus full-time jobs. Yes, this portion of the jobs will be done remotely, not in Louisiana. The Economic Development Agency does not have that information. But also it's important to bear in mind that information needs to be obtained for this case. It needs to be put into this case as evidence in order to use it to either find that the project is in the public interest and find that the 7 generating stations need to be built. Otherwise, it's not information the commissioners would be allowed to consider because it hasn't been put into this proceeding.
Well, economic development is a totally different governmental entity of,
Yes, sir.
with the governor, the Louisiana legislature, Have you asked them these questions?
My understanding is they don't have the information. I'm not personally
The
specific. but they
governor
don't
and the
have it.
Louisiana legislature and economic development, they don't know the answer to these
They
questions?
don't know the answer to the
And you're
questions.
here asking us, okay?
As part of this
And
proceeding.
have you asked
yes.
them? Have you filed some request with them for this,
No, sir, because we want the information in this proceeding. That's the only way we can use it to develop our case with regard to whether Entergy's application should be approved. So the fact that, and I have been told by others that the economic development does not have the information we're asking for, the governor's office does not have the information we're asking for. Meta has refused to provide that information to anybody. Entergy does not have the information we're asking for. So no one has it but Meta. So
Okay.
All right.
Sue, one of your colleagues, witnesses today mentioned the news. There's plenty of news here today, and I read the articles too. I think they're doing a stand-up job of reporting the jobs and opportunity that are happening up around the state in Northeast Louisiana, starting in Northeast and matriculating all the way down to the river in New Orleans with river traffic increasing. We had a hearing in August of 2025 where we had every economic development officer in Northeast Louisiana and around the state testifying for the first, for Meta, for the Laidley deal. And I assume we're gonna have the same group that's gonna be testifying again. I would invite you to look at the video again to hear the economic development aspect of this deal because it's going to be even bigger when you talk about the bigger size of the deal, when we talk about expanding this. So, I mean, you can deduce what the economic development will be based upon the testimony from August 2025, and then look at it from now, and you could read the articles written by any number of outlets, whether it's The Advocate, whether it's the Illuminator, whether it's WFB, whether it's any outlet that you want is reporting on the jobs and opportunity right now, from restaurants to manufacturing. So I just think it is a misstatement to say that the only people that have this information is Meta and/or Entergy. This information is readily accessible to the public by watching the news and understanding what's happening. I think what you're looking for is more granular data, and that's fine. I just don't necessarily think that that's appropriate relative to our role right here.
Well, sir, I respectfully disagree. What we're looking for is, what you're talking about is the economic development due to the construction, which we don't argue there's been a lot of construction and a lot of jobs. What we want to know is what's the long-term economic development? When it's finished construction and all those people leave, how many jobs is the data center actually going to create on a permanent basis? Because
Is 10 years short-term or long-term? I'm just curious. If a construction job lasts 10 years, you consider that short-term?
I consider that short term.
Okay, I disagree. If you give me a restaurant for 10 years that's humming along for 10 years, I'd take it today and I'd cruise into retirement. That's not short-term, 10 years to me.
Well, it must be an
That's a big
amazing
distinction.
restaurant if you can retire after 10 years. But there are two phases. There's a construction phase and there's a permanent operation phase. And what we're looking at with regard to the jobs and economic development is the permanent phase, not the construction phase.
Thank you. We're going to move on to the next three.
Chairman, I have a
I'm
question
sorry.
for-
Go ahead.
Thank you, Mr. Chairman. Ms. Miller, when we go back, I'm going back to the actual hearing, the first hearing of the subpoena, and I want to make sure I'm clarifying some things correctly. Did Entergy file any briefs or motions in support or opposition to the motion to subpoena, to your knowledge?
No, as to my knowledge, and it should have been docketed in the case if they had filed. And are you saying Entergy or Meta? I'm sorry.
Entergy.
Entergy, yes. Entergy opposed the initial motion, and as did staff.
Exactly. Okay. And when we go to the ALJ's hearing on request one, let's start there with the analyst. She basically states that this is not a typical utility investment. Would you agree with her justification there?
Yes, I do.
And that she states, and I quote her, "This data is relevant to the Commission's public interest determination in this matter, and to the extent that it is responsive, data that has not previously been provided, and it should be provided in order to complete the evidentiary record in that matter." Would you agree with her there?
Yes, I would.
Meta subsequently says that this information is highly marketed and sensitive. What is your rationale against their plea in their filing that is why we should deny the motion based off of what they say is material alleged to be of trade secret and confidential of nature?
Information is not denied just because it's confidential or trade secret. Protections are put in place to avoid it being released, and we have an NDA in this case. And as we mentioned, my own clients can't see some of the information because of the NDA in this case at this point. So just the fact that it's confidential or trade secret is not in and of itself a reason to deny access to any information. And you don't have it before you because it's in the order on the motion to quash. The ALJ also stated that Meta didn't prove how sensitive this information was and that it was trade secrets and just too confidential to give. But that's not even the standard. The fact that it's confidential goes to the process.
Thank you. Let's go to the second motion, the second request that was granted by the ALJ on the energy usage. In the trial, it was asked the question of how Entergy submits that information. Can you refresh my memory on what Entergy's response was to the judge's question on how?
Commissioner Lewis, can I ask you a question? Are you going to be basically going through the entire procedure of the ALJ hearing with this witness as the attorney for them?
Yes, sir.
Okay. This is a comment period and not a refresher of the actual hearing.
She's a witness at the trial. That's what
Yes,
we
I
ask.
understand.
We ask
but
people at the table all the
this is
time.
This is a comment period. This isn't a refresher.
It is comments on the motion, and I'm asking her comments
Well-
about the proceeding, which is the motion.
Okay, well.
That is what I'm doing.
I understand. Well, I'm asking you a question. So what I'm asking.
And it was my time, actually, so I would like to continue asking my question so we
Nobody's
can move on.
restricted your time. I'm asking you a question.
I'm saying I was
asking-
asking her a question, you interrupted. I didn't interrupt you.
I'm the chairman. I
love
have to
that
run the
for you.
meeting, and I have to ask you a question. So if you want to restrict the questions about the issue before the commission, about where we are now, that's fine. But what I don't want to do is go through the entire process of the ALJ recommendation, understanding which that the ALJs do not make decisions before the Public Service Commission. The commissioners make the decisions. The ALJs make recommendations to the commission for the commissioners to make final decisions. So I understand what you're saying, but what I'd like to do is restrict it to this particular issue, and so we can move the matter forward, because I understand we have 20 witnesses, and we want to get to all of them. And so I'd ask you to just be restrictive about where we're going with this and not go through the entire hearing matter if you can.
Thank you for that history lesson, but I will respectfully decline you, because when you have the opportunity to say whatever you want, the rest of us just sit here and listen. So I'm going to continue as I was, because the motion at the table
that's fine.
was on the subpoena that the ALJ wrote.
Brace yourself.
Meta asked for a review of the ALJ subpoena. Therefore, I'm going to ask questions about why the ALJ is wrong or right. That is what our job is to do. If that's not what you want to do, I'm sorry, but I'm here to do the job that my people elected me to do, and it's not to listen to you. So I will continue with my questions. Ms. Miller, in your briefing, one of the questions that was posed to you or was suggested to you that the only reason that the NPOs, you filed this motion to subpoena was to delay the proceeding. That it was a motion of delay and that we have already seen that it had been declined once in the previous proceeding and because of timing. And so can you explain to me why you filed this much earlier than you did the last time versus what we saw in the first proceeding?
Well, exactly because of that timing issue. Our subpoena was denied in the first Meta case because the ALJ said we'd asked for it too late, that discovery had already ended, that it was too close to the hearing, and so she was going to deny our request for the information. So in this instance, we still need that information. This is not a delaying tactic. We didn't ask for a stay of the procedural schedule. We didn't ask for any changes in the procedural schedule whatsoever with regard to delays in testimony or anything like that. We still need the information, and we took the ALJ's instructions to heart and filed it much earlier because of the decision that was made in the first proceeding.
Since that subpoena has been issued and since the following briefs and trials, has Meta asked for a limitation of what you are considering in either request 1 or request 2?
No, as a matter of fact, during the hearing on the motion to quash, the ALJ, they said it was burdensome and would be too costly and everything, and the ALJ asked them to provide information on how it could be narrowed, and they absolutely refused. They said it's just a burden and we won't participate in any discussion process regarding how it can be altered so that it won't be a burden.
And my last point for you, you raised in your brief that you believe Meta did not have standing to file this one motion to stay and motion to quash, and now the subsequently motion for immediate review because they are not a party to the case. Can you expand on why that's the NPO's position in this case, that Meta's request is not even valid because they did not participate as a formal party to the case?
Yeah. It's not because they didn't participate as a formal party with regard to going before the ALJ, particularly with regard to the motion to quash. Since the subpoena went to them, they had a right to ask for a motion to quash. The interlocutory rule, Rule 57, specifically says a party can file a motion for interlocutory ruling. It does not say anyone else can. And the rules of statutory construction, which apply to regulations, say they should have to be held to their terms. And the term here says party can ask for an interlocutory ruling, not anyone else. So our argument is not that they couldn't appear before the ALJ to argue against the motion and to file their motion to quash. Our argument is that they could not file for an interlocutory ruling before the commission. And I think it's important to note in the motion before you, Meta's the one who appealed that. Entergy did not file a motion for interlocutory ruling, and the staff did not file a motion for interlocutory ruling, even though they're the only two parties who participated in that first phase of the case. So Meta didn't even participate in that first phase of the case, yet they're the ones who filed an interlocutory motion as a non-party. They specifically keep saying they are a non-party. And they're the ones who filed the motion, even though the first phase of the proceeding they didn't participate in.
Okay, thank you.
Y'all are excused, and next three, if y'all will come up.
She's for it or against it? She's for it, but she thought it was today. I think they did.
Yeah, push your little dangerous. Push your little.
You have to bring it pretty close to you, otherwise we won't hear you.
Okay, how's this?
That's good.
My name is Gabrielle Gemma. I'm a retired worker living on Social Security, and I'm speaking for the Louisiana Workers' Council. I have a statement to read, but I want to go off script for a moment based on what Commissioner, pardon me,
Francis is on the end.
gentleman right here, said that, well, all this information is public. You can just go to the newspapers and you can find out there what the jobs, all the jobs that are going to be created. I
Don't
want to
fuck.
first
Tucson.
remind everybody here.
Tucson said that, not me.
I first want to remind everybody here that under the Landry administration, the ITAP, which is the Industrial Taxation Exemption something, repealed the necessity for tax exemptions to be given on the basis of job creation. And therefore, the $3.3 billion tax exemptions for 20 years that are being given to the Meta Corporation are not.
We don't deal
Well,
with tax
this was
issues.
brought up in this
Right.
hearing, so as from the purpose of squashing the subpoena by saying that all this information is public, in effect, it's not public by the Industrial Development Board at all, because it's not a requirement
Just to let
any
you know,
longer
we're not
that
doing the quash today. This is, the quash
this
will
is
be in.
about the subpoena.
Yeah, but the quash motion is in September. This is just about it's the first issue.
Well, my
The staff
understanding.
will identify.
But I
it.
just want to make that point, being as it came up, that information, and in fact, what was revealed by the advocate and revealed by the illuminator in the past was that promises of job creation that were given for the basis of tax exemption were not fulfilled in any manner at all. And that is why it is very important that on the record it be stated what permanent jobs, if any, full-time, part-time, will be and where they will be working from actually must be read into the record of this proceeding. The people of the state of Louisiana have an inalienable rights, meaning it cannot be taken from us, to have clean air and water, and to the conservation of farm, recreation land and its wildlife, and to the maintenance of life by consistent, uninterrupted, and affordable electricity, which is essential to all aspects of our lives. The protection of those inalienable rights, meaning rights of which we cannot be deprived, should be the job of the Public Service Commission. Unfortunately, by virtue of millions of campaign contributions from electric, oil, and gas companies and their suppliers, and by virtue of political ideology that places corporations before people and assumes authority it has no legal, moral, or divine right to exercise, this has not been the case. The Public Service Commission majority has bowed at the altar of a guaranteed whopping $9.7 billion profit on investment for Entergy. The Hyperion project alone would guarantee Entergy $8 billion in profit from its investment, while the company sinks all its capital investment into new plants and constant electricity for Meta, ignoring critical infrastructure needs throughout the entire state, all parishes, including Orleans Parish. The debt incurred from this capital investment will be passed on to residential and small business customers. There is no guarantee by law, just lip service from Governor Landry and pledges from President Trump that lower bills, consistent service, and rapid restoration of power to the people after a storm will occur. Despite Commissioner Skermetta's claims that conservatism, that is the policy of corporate profit over people, is divinely granted, it is not true. Undoubtedly, this has
Ms. Gemma.
personally benefited him as he ends his PSC term for this year.
Your time's slowly expiring. She's asking you to wrap it up.
Okay, I'm wrapping up. To
Thank
become
you.
first Deputy Secretary of the U.S. Department of Energy. And for this reason, I would like to ask Commissioner Skermetta to recuse himself from a vote on the issue of the subpoena, as the Department of Energy's policy is clearly that of drill, baby, drill, and to go ahead fast-track data centers, and to fast-track the creation of any and all power and gas plants, or any plants, nuclear plants, in order to make that happen, and therefore is biased on the issue of whether or not anything should be done in terms of transparency, information being given to the public. It is the public at the last resort that has the right to say whether or not this is for the good of the public alone, not just a small group of people that sit on this commission. And the only way that can be done is to give full and total information to the people of this state. If you want to guarantee that the people of the state will not be harmed by this, then put that specifically in writing, not by vague promises and pledges that hold no water. It has been shown.
Sorry, ma'am, your time is well overdue.
Okay, on my last sentence. It has been well shown in other states where these data centers have been set up, how people have suffered from high costs and pollution of all types from these data centers.
Okay,
And it is
Ms.
our position that
Ms.
this subpoena should not be squashed,
ma'am.
and that Commissioner Skermetta recuse himself from this proceeding.
Thank you very much.
Thank
All
you.
right, next person. What a share the microphone over, whoever wants to go next.
Good morning. My name is Devor Levy-Perlman, and I'm a member of the Louisiana Party for Socialism and Liberation, and I'm a volunteer with the Take Back the Power campaign. In conversations that I've had with community members, I've heard countless people who have expressed nothing but outrage over the undemocratic nature of this Meta and Entergy deal. It is absolutely unacceptable that countless public employees, including Governor Landry himself, have signed NDAs, non-disclosure agreements, with Meta to shield them from accountability and deny people transparency over the data center being built in their own backyard. When they sign NDAs, it shows that they are afraid of the people. They fear how the working people of our state would respond to the truth about this corrupt backdoor deal. If this deal is so good for Louisianans, why did they work so hard to keep it out of the public eye? They make decisions over our heads, and we end up paying the price. This is not a democratic process. This is a circle of wealthy elites, of big corporations who are making all the decisions that impact our lives and buying out the politicians. And this remains regardless of whatever party is in office or who you vote in. So I want to invite everyone here, if you want to be a part of a real grassroots, people-powered movement to fight back against the data centers killing our communities, against corruption, and demand a real democracy for working people in our state, please join us in our people-powered campaign, Take Back the Power. We're running a statewide campaign to demand
we're not
no more
allowing
data
a
centers on
campaign
our
here.
dime.
We're talking about a procedure.
Yes,
We're
sir,
not
it's
talking
germane.
about
this is
Number
campaign.
2, a cap on utility hikes. Number 3, Entergy out of Louisiana politics.
Sorry.
And number 4,
right.
democratic control over our
right.
utilities.
Well, thank you very
So
much.
we need people to stand up and be a part of this movement. Thank you very much.
Thank you very much. So if we could actually, respect the process, I'd appreciate it. We're not talking about campaigns. We're not talking about other issues. We're talking about the issue that we're talking about right now about the subpoena. So I'd appreciate it. So thank you very much. Yes, sir. You have comments?
Yes, my name is Joseph Rosenzweig. I'm a warehouse worker. I'm a Teamster. I live in Orleans Parish, and I'm here to oppose the motion before us and to proceed with the ruling of the ALJ to subpoena this information. This is critical information to the public. I want to emphasize that word, public. And in fact, this body is called the Public Service Commission. And yet, the public is seeming to be cut out at every step of the critical information to our lives. The Public Service Commission, which guarantees an $8 billion profit for Entergy already, and which sees billions of dollars in potential for this Hyperion project, is ignoring the concerns that we have, not least the issue of the load to the grid. Already, just last month, the grid in the Northeast was compromised by a surge due to the data centers in Virginia, which consume, at this point, 1/3 of the state's energy. This is going to affect every person that resides in the state of Louisiana. We experienced an outage in Orleans Parish after Hurricane Ida of 2 weeks, during which time hundreds of seniors in our community perished because of the heat. We've experienced this in the aftermath of hurricanes, whether it's Laura or Katrina, and we need to be guaranteed that the residents of New Orleans, which prop this state up, whose labor is what the entire state of Louisiana runs on, have some guarantee of security, some guarantee that they're going to be able to cool themselves when a storm hits, some guarantee that they'll be able to heat themselves when a winter storm happens, as happened in Texas. And so we are concerned very much for the reliability of the grid, which we have already seen has been compromised in some instances, for example, in the case of Virginia. And we need, therefore, to have as much information as we possibly can about this project and the dangers that it poses to the residents of Louisiana.
Okay, thank you very much. I will point out that the Public Service Commission does not regulate the city of New Orleans electric systems, just for, sorry, I just.
We are
making
part of
comment.
we're part of
Oh, I-
MISO, right? Which extends
I'm
all the
not-
way up to
I'm not-
Manitoba.
I'm not interacting
And-
with you, I'm just making a statement. Also, we have 3 more people coming up?
We have multiple people.
I know,
coming
but-
up.
Our lives are on the line right here.
I understand.
I know you've got your appointment approaching, which will be very profitable for you at the Department of Energy.
Yeah.
Okay,
Obviously-
okay.
Obviously, you should read. So, yeah.
Okay, in order
You should,
to move
you
on
should-
and
you
get
should-
Guarantee
this
that the people,
done,
the
Go
people
sit.
so
are
we will
aware of
call
what's
up
going on.
People get
Jalen
paid.
Robertson, Raylan Jacobs,
Call 6 people up, please.
Jude Terrell. Those 3 may go to the table. These 3 can come sit in these chairs. Travis London, Marianne Muscat, and Jessica Schutz. And I will ask you guys again to limit comments directly to the motion to quash subpoena and the information that is asked in that subpoena and not on the broader topics. I appreciate that. Thank you.
Y'all can hear me? Chair, y'all can hear me?
Yeah, go ahead, please.
Cool.
Just say your name first
Bad.
and watch the microphone, make sure they can hear you.
So, my name is Jalen Robertson. I'm with the DSA, the Democratic Socialists of America. I hear you talking about jobs, but I don't care if a company is bringing me jobs, if a data plan is bringing me jobs, if it's going to be killing me over 50 years, you know? What's the point of that? If I'm going to be going into work every day, inhaling fumes and drinking water that's killing me, I don't care if I'm making $30,000 a year. What I do want to know is, how many jobs are they bringing? Like they said, full-time, part-time, remote, and state. I want to know how much energy are they going to use. I want to know how many parts per measure of pollution are they going to be putting into the state, and that's going to flow all the way around this country. I want to know how much of the cost is going to be passed down to every single Louisianian. I want to know how many outages are going to happen, and in those outages, how many homes are going to be affected, how many families are going to go without electricity, without heat, without AC, without the ability to charge their phones. And y'all have the ability to ensure that we know that with your decision on this motion. So the question that needs to be asked for you, for yourselves, for your God or whatever higher power is, how many zeros can Meta put on that check to where you can forsake your neighbors, your constituents, your wife, if you have one, your children, if they like you, your grandparents, if they're still alive, God help them. You know, like, at what point are you willing to say fuck you to these people? You know?
Hey, ease up with the language, please.
My bad. Sorry, I guess. Not sorry. But I guess that's the end. I yield my time.
Thank you very much. Next person, please.
Morning, gentlemen. My name is Jude Terrell. I'm the president of the Student Alliance for AI Reform at LSU. Our organization fights for AI to be used for the benefit of everyday people. Meta, the company constructing the colossal AI data center in North Louisiana, is claiming that it will be a boon for Louisianans. However, myself and many of the people who join me in this chamber today have our doubts. We are rightly concerned that the Hyperion Data Center project, one of the largest of its kind in the country, will not generate the 5,000 plus jobs that Meta claims it will, and does not need the 7 new gas plants the company wants to build to power it. 75%, that is 3/4 of Louisiana's electricity, comes from natural gas. When a new gas plant is built, energy demand increases, leading to an almost guaranteed rise in energy costs for Louisianans. We are already paying hand over fist in grocery stores and at the pump. No one needs their electric bill to go up too. No one in their right mind can support a project that could raise energy costs for their family and not even generate the jobs for their neighbors that Meta says that it will. Members of the Public Service Commission, today you have the power to make what should be an easy decision to uphold the subpoena already issued to Meta. This subpoena simply requests for the corporation to verify their claims about the energy needed and the jobs to be created by the giant data center project taking place just a few hours north of here. I hope you make the right decision and prove to everyone that this body is committed to holding corporations accountable to the people of our state. Thank you for your time.
Thank you. Next person, please.
How's it going? Raynell Jacobs with the Democratic Socialists of America. How's it going, gentlemen? I'll try to keep the motion at hand. Of course, no one likes data centers. Let's start off with the jobs. Once again, we've already discussed it, 3 people at this table so far. When it comes to data centers specifically, the work done there is digital mainly once everything's sort of established. And as someone in the field, once it goes to a digital aspect, that no longer needs to be a tangible person working there, specifically remote jobs. Whenever those jobs become remote, they're accessible not just to U.S., other states, other bodies, other cities. They're also accessible overseas. For example, not to air out my own company, but recently we just said, no, we don't really need U.S. workers on our IT team. We'll just outsource that to Bangladesh. It was easy, it was done. Big corp, another win for them. We now have so many jobs going to a different country that will never see a US dollar again. What I'm saying is, it can easily be done again with Meta, with this data center over and over and over again. All that we're gonna have in Louisiana is maybe a couple HVAC vendors that come in and make sure the AC is still running and such. We're losing a lot on the back end of this deal, which I'm sure you guys know. I'm certain you guys know. But again, it is your decision. I prefer transparency before making any, and I truly mean any deal, but to each their own. It's your choice.
Are you in radio?
How'd you guess?
You got a great voice.
Thank you.
Well, thank you very much, and we'd like to go ahead and switch to the next 3
Yeah,
folks.
as you 3 come up, I'll call 3
and
more
they're
to
gonna
come
call
up.
3 more up.
Scott Reed, Austin, is it Lawson, and James Hyatt.
And as you sit down, just
Yeah, and-
share the microphone and identify yourself, and you can begin when you're ready.
With HVAC technician. Take care of $100 billion of assets. That's all the jobs, a couple of HVAC technicians.
Hello, my name is Travis London. I'm from Step Up, Louisiana. Looking at TikTok, looking at YouTube, they have many people across the nation that have been complaining about the AIs, data centers. We're hoping that the people that come here, you know, the Meta and so forth, will be more transparent with the public. In North Virginia, people are getting heavily taxed about the power grid and threatening the residential rate hikes. You got Phoenix, Arizona, they will be facing chronic conditions for wars with the drought and so forth. They were complaining about the gallons of water. You got Atlanta, you got Fayette County, Georgia. It was complaining about the sudden drops in municipal water pressures and unauthorized usage. Right now, Texas is gonna have a bunch of lawsuits heading their way about different people complaining about the gallons of water and not having different people telling them about how much water they're gonna be consuming. You have, like I say, they have all these people, landowners, matter of fact, complaining all across the country about the AI centers. With these AI centers also, these centers also use carbon capture.
Okay, Mr. Robertson, I think we're only on the subpoena, which is related to the information requested. So the water issues, that all of that is not really what the commission is considering today. So if you have comments opposing the issuance of subpoena or supporting the issuance of the subpoena, we will accept those comments.
Like I say, the different projects, like I've been here with Owens and also McCormick on tackling some of these projects. They're Republicans. I've been with Democrats about to be going to Ascension Parish for the same type of project that's probably proposed for Ascension Parish. They're gonna be at 5:30. I'm here for the people, and I hear about different party strifes and so forth. And I just hope y'all consider different people's testimonies, and if I could give y'all different news reports on all these different counties across the nation about their problem with AI, I would love to submit to that to y'all to your emails. Thank you.
Thank you.
Thanks. Good morning. My name is Marianne Mashad. I am with the League of Women Voters in Louisiana. At our national convention, we also passed a resolution about privatizing utilities and natural resources, which I believe Meta and this data center are doing. By now, you've heard the logical, ethical, and in the long term, especially if you consider one's legacy and next steps, to uphold the rule of law and your duty to us, your constituents and citizens of Louisiana, and vote to oppose this motion to reject the subpoena. I'm in support of the subpoena and having Meta come clean. We can handle the truth. The question is, can you? What I intend to speak about is to remind you of the bigger picture, our future in the eyes of our kids and their kids, and they're watching us and you for how you vote, how to do your job, and are you going to do your job and protect our fundamental belief in the rule of law over man, or will you abdicate that responsibility and let these companies spread their sweet stories of lies about what they will take from us? Fresh water, necessary for life, clean air, threatened by gas power plants, cleaner is not clean, and false promises of permanent jobs in glorious numbers. Yes, I speak to your self-interest on top of what all has been said, to take a moment and consider where you will stand when history records this moment, because it will, and your grandchildren ask what you did for all of us. Thank you.
Okay, go ahead.
Hello, my name is Jessica. I'm a resident here in Baton Rouge. I'm also a volunteer for the Take Back the Power initiative. I want to know how Louisianians can be sure that this project won't raise our utility bills if project information isn't even made public. Across the country, we've seen that data centers mean one thing: higher electricity bills as the cost for these projects get pushed onto the working class. Now, Governor Jeff Landry has attempted to reassure the public that our bills won't go up, but his flimsy executive order raises more questions than answers. How can we trust him if he and members of his administration are signing NDAs? If this project will bring such huge benefits to Louisianians, what is there to hide? One only needs to look at what happened to Richland Parish, by the way, to see how the cost of living would skyrocket. The project has already increased the demanding for housing, and rent for trailer park lots is somewhere in some areas have increased by over 500%. And that's already resulted in at least one family becoming homeless. Here in Baton Rouge, people's wallets are already stretched thin for subpar service from Entergy. Just recently, the power went out at my apartment for 16 hours. That means we had to replace all of the food in our fridge, adding on to the cost of living. It means that working class people can't wash their clothes for work the next day. So if Entergy can't even deliver adequate service as it stands right now, what makes us think their grid can support the largest data center in the world? And even if they can support the data center, what's to stop Entergy from raising our rates to maintain their same lackluster standards?
Okay, Ms. Schutz, we're only on the subpoena. Again, you're kind of going off onto other issues.
Sure, I'm almost done. We are not numbers on Entergy or Meta's spreadsheets. We're human beings who deserve a dignified life. Louisianians can't afford Entergy's risky adventures, and we deserve to know what's happening.
All right, thank you very much. I'll excuse next person.
You're definitely not the last one. Austin Lawson and James Hyde, if you're in the room. And then 3 can come sit in the queue: Kendall Berry, Lee Patterson, and Rebecca Jones. Kendall Perry, Lee Patterson, Rebecca Jones, going once, going twice. Thank you.
You can begin whenever you're ready.
Hi, Commissioners. How are we doing today? My name is Austin Lawson. I'm representing the Matt Gromlich for Congress campaign, and I wanted to come up here and speak today in favor of the subpoena, and I'm really glad that the subpoena is the thing that we're here talking about, because it's very representative of how these data center talks have been going with the Public Service Commission, and not just the data center talks, anything, right? Data centers, electricity rate increases, dealings they do with these energy companies, it's all symbolic of what the Public Service Commission continues to do over and over again, which is act like it's not their problem or it's not their authority when you are elected to do this, right? When I came in today, within the span of 5 minutes, we heard, oh, you know, the AJS doesn't have authority to do that. Oh, but 5 minutes before that, oh, the Public Service Commission, we don't have the authority to do that. I think people are tired of hearing this gaslighting coming from the commissioners. Every one of you, except you, Devontae, thank you for what you do. But I think people are just sick and tired of coming to the Public Service Commission, making their grievances feel heard. And I mean, we've had multiple commissioners condescend towards the people coming up to speak. We've had the rules for people speaking tight, and people have been spoken over multiple times. And I think it really encapsulates the frustration that people have with this Public Service Commission. You know, I was running for that man's seat right there. And when I was going around talking to everyone in my great district of seat 5, I was talking to folks and I was like, hey, what do you think about your Public Service Commissioner? They don't even know who he is. The Public Service Commission has this history of operating under the shade of night and behind closed doors, where they want to go and get in bed with the electricity companies or with any big utility company that's coming here into Louisiana, these data centers, at the expense of their own constituents. Now, I could go over how you guys are selling out your constituents, but other people have already gone over that.
Can we keep it to the issue about the subpoena, please?
Well, I believe the subpoena has a greater effect on the transparency issue generally, right? I think it's a microcosm for what we're talking about here today. And it's why I'm glad I got to talk about it. You know, the idea that we have to debate if this, you know, I came from Shreveport, right? That's 5 hours away. The idea that I would have to drive 5 hours down to the Capitol to try and convince people on a commission to do their damn job. I mean, that's what it is, right? We need to make sure that these investments are what they say they are. And when I have commissioners up here talking about, oh, you know, we'll push it back even though we have a room full of people here to speak today, you know, you can only comment on it on this very specific way, and then when you do, we're going to overtalk you. I think it just sends the wrong message to the people who elect you, and I think you should do a better job representing your district. And honestly, I think your district constituents should pick a different commissioner. Thank you.
Next person, please. You need to share your microphone. You next.
Sure. Hi. Good morning. My name is James Hyatt. I am from Lake Charles. Commissioner Francis, good to see you again. And, you know, I drove over this morning also, and it is such a beautiful state we live in to drive across that Chafflaya Basin and watch the sunrise. And that's why we should protect it as much as we can. I've heard a lot here today already about economic development. That economic development should not be voodoo economic development. We should see the work, they should show the work and show the data. If it is so readily available, why is Meta fighting this so hard? You're going to eventually vote on a determination of public interest. How can you possibly make that without the full data, without understanding how many jobs will be? We have seen this already many times, especially in Southwest Louisiana, promises of jobs, 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 economic prosperity that does not actually go to the people who live there. In this, Meta is one of the richest companies that has ever existed, yet providing energy demand and permanent job creation data is somehow a step too far for them. It is insane. They're asking the commission to sign off on 7 new gas plants while refusing to release the data that would tell you whether that's actually what's needed. Meta publicly stated that the power they need is less than half of what Entergy is proposing to build for them. The judge's own ruling found that Entergy doesn't even have the underlying data behind Meta's numbers. So the company asking you to approve billions of dollars in new infrastructure can't explain on record why it needs that much. How can you make a public interest determination without the facts? A very limited, narrow scope of facts, job creation, energy demand, and what the impacts will be to the ratepayers of this state. Pledges and promises that are without teeth, we have no enforceable action, that, like the governor has tried, does not provide for the ratepayers. This is very simple. They're asking for the information that led to the determination of, is it going to be 12 jobs? Is it going to be 10,000 jobs? Is it going to cost me and my family, who are Entergy customers, to subsidize what's already been one of the richest companies in the world, already subsidized with billions of dollars in sales tax exemptions? We should not be subsidizing anymore or paying for large companies. I'll leave you with this. These are the two questions Meta is fighting hardest to keep sealed. What are the electricity demand? How many permanent jobs will actually be created? And these are exactly the two questions the judge already ruled are relevant in your public interest determination. So we've already given this company so many tax exemptions. You are the regulators charged with protecting the public interest. And I know each and every one of you love this state and do care about your constituents. I think this is an opportunity to pull back the curtain and actually be transparent and let us know how this will benefit us, and it's not some voodoo economics that will just cause greater harm. Thank you for your time. Thanks for the opportunity to speak.
Next person, please. Whenever you're ready.
Good morning. My name is Scott Reed. I'd like to thank you guys for allowing me to comment this morning. A brief background on how I became involved in this process. In May, I was initially contacted by Energy to survey property on in central Louisiana. It was going to be impacted by a transmission line serving this data center. I had no idea what was happening. Wasn't familiar with the project. After an initial investigation, I determined that the proposed 3/4 mile long transmission line that affected only my property would consume roughly 22 acres. Upon drilling down on scant details of the project and the energy demands of data centers, I became more widely concerned. I learned an ESA was executed between Energy and Meta, but was unavailable publicly, protected by a wall of NDAs, and considered a private contract between two private companies. If Energy is considered a private company for protection of its agreements, then how are they also considered a public company to exercise expropriation powers for transmission lines? Transmission lines for these projects will encumber 240 miles, or roughly 6,700 acres of private Louisiana land permanently. Some of it using the power of expropriation. Roughly twice the area consumed by Meta's data center as it currently sits. I understand how we got here. We got here by offering Meta $3.3 billion in tax incentives to create roughly 500 jobs. I understand that employment number may be less now and the tax incentives may be greater, but let's take Meta and Louisiana at their initial work. By my math, that's roughly $6.6 million per job we're paying for those 500 jobs, those permanent jobs. I'm worried about private property subjected to expropriation for a single large load customer and the corporate confiscation it implies. Yes. Governor Landry assured the public on May 5th of this year that private property rights are sacrosanct in Louisiana. I hope the Louisiana Public Service Commission shares those same values. I'm worried about the long-term impact to energy rate base after the initial term of the ESA expires in what I understand to be 20 years. It's my understanding that the infrastructure requested for this project has a lifespan of 40 to 50 years, and in some instances longer. My request to the Commission is that they vote to allow full transparency into jobs created, power requirement calculations, and full details of the ESA with Energy and Meta for Entergy and citizens of Louisiana to determine if the current plans on the table are a good idea. What assurances does Louisiana and the Louisiana ratepayer have that any costs surviving past any unforeseen circumstances with Meta, they will not be left on the hook? Without your vote for transparency, we will have none. Thank you.
Thank you very much. Y'all are excused, and if the next three want to come up, and you can call up the next three.
The next three in the queue are Lindsay Garcia, Velva Bowles, and Jacqueline Brooke.
Mr. Chairman,
Yes, sir.
I got a question for Secretary Fry.
Go ahead, Secretary.
We giving out any tax incentives?
Not to my knowledge.
Okay. All right.
Sorry, go ahead whenever you're ready.
Good morning, Commissioners.
My name is Kendall Berry. I live in Orleans Parish. I'm a member of the Party for Socialism and Liberation and an organizer with the Take Back the Power campaign. We are here to demand full transparency about Meta and Entergy's backdoor dealings, because we have questions. My first question is just how much money is Meta putting into this project? And why are they jumping through so many hoops to make themselves an escape route? Meta created a separate legal entity called Beignet Investors the very day you approved Entergy's building of 3 new power plants last year to absorb their risk, and they're pushing for even more now. Meta has also constructed an agreement with the private credit firm Blue Owl, allowing them to completely walk away after just 4...
Can we connect it to the motion, the subpoena itself? Because we are talking about a separate docket that isn't even in front of the commission today. Well, we're trying to let everyone speak today, and if we let everyone speak everything they needed to say, we would be here till tonight. So we are trying to limit this and let you guys speak. But again, the only thing that is in front of this commission is the subpoena.
Okay, your constituents deserve to know all the details. All the details about where all the money needed to build and maintain these new power plants is going to come from. And if those sources are reliable enough to not just abandon us at the first sign of trouble. Meta has gone to incredible lengths to conceal as much information as possible about this project, going so far as to sign an NDA with our governor, who in turn made over 100 of his employees sign NDAs with their office as well. We are sick and tired of big tech billionaires making backdoor deals with our politicians. We are tired of having no say in how our electricity grid is used, while our utility bills continue to rise, while we're already struggling to pay for housing costs, groceries, gas. The real reason Meta is so intent on doing business in the shadows like this is because if they were to disclose all of the details of this project, the public would object. They are scared because all across the country, people's power is stopping data center construction in their tracks. The people demand transparency. I hope you will allow this subpoena to go through.
Thank you very much. Next. I would like to point out, just before we move on, none of the commissioners have signed any NDAs. Kelly, so next person, please.
Unless Devontae.
Oh, I ain't signed
Okay.
nothing.
There you go.
I have not signed an NDA. The chairman has not signed one, nor has former
And,
chairman.
another little notice that the chairman owns not a single share of stock at all, of anything. So next person, please. Ma'am?
Did you receive any of the motions from Entergy?
You can wait till it's your turn. You can come up. Okay. So please, you need a microphone. You need to slide it over. And just pull it up close to you.
All right. Good morning. My name is Lee Patterson. I'm an organizer with the Take Back the Power campaign. I'm also an environmental scientist. I've done work all over the state. And to me, these data centers look like the latest instance of our elected officials sacrificing the health and safety of Louisiana's people and environment for corporate profits. We sacrificed our coast for oil and gas. We sacrificed our clean air for the petrochemical industry. And what has that done for the people of Louisiana? Our coast is still disintegrating. Taxpayers are constantly on the hook for cleaning up the messes these plants make. We have some of the highest cancer rates in the country. Everybody here is dirt poor, and we're dead last in almost every quality of life indicator. I know that Meta has information up on their website about all their supposed mitigation measures that they're going to do for this data center. But my question is, we've been fed this information like this time and time again by every new plant they want to put in. And why should we expect any different this time? Everybody who lives in Louisiana knows how inadequate our environmental regulators are at actually protecting people. If they were good at their job, we wouldn't have the highest cancer rates in the country. So, after all the cloak and dagger stuff that we've seen going into this data center up to this point, what would make me what would make the people of Louisiana believe that we are going to be protected against these potential negative environmental impacts? How do we know that Meta is going to be held any more accountable than Exxon or CF Industries or Dow? You know, at very least, I think at very least we should be able to see the data that Meta has to back up these claims that they're making.
Thank you very much. Next person, please.
Hello, my name is Rebecca. I'm a volunteer with Take Back the Power, and I live here in Baton Rouge. I'm curious to know how many jobs are actually forever. We deserve information to be released about the real number of jobs this project will create. Meta claims that this project will create thousands new jobs, permanent jobs. But what's the breakdown? Are we supposed to just take that at their word? The forever jobs are thousands until the construction is complete, but then what? Maybe 50, 25? Thousands of jobs doesn't make up for rising energy bills, depleted fresh water resources, toxic pollutants, and all the risks of communities that data centers are creating in working class communities across the nation. As a lifelong Louisianian and a parent, the future of our state is important to me, and I take claims about jobs being created very seriously. I want to see real economic development that actually benefits my children's future. Investment in healthcare, coastal restoration, resilient infrastructure, not short-sighted projects that will fill the pockets of billionaires while working people lose in the long run. But we need to see the proof for ourselves. A recent study by the Brookings Institute suggests that naive estimates about jobs without evidence can be overstated by a factor of 3. We need to know what is leading Meta to make this claim about thousands of jobs and if there's any merit to it. Without information released to the public, we're just crossing our fingers and hoping that a giant corporation that operates in its own interest is telling us the truth. This raises the question, is Meta's priority the welfare of working class Louisianans or its own bottom line? I think we know the answer. Thank you.
Thank you very much. Next, folks.
Okay, Jacqueline, you can go up. Yeah, thank you. Jacqueline Book, you are up, and then on cue is Kelly Ward, Trevor Trahan, and Kenneth. I cannot read what you have written.
We have another space up front if you want to fill it.
Yeah, there's a Jacqueline Book that I've called going once.
So somebody can come up here.
Yeah, so you can go up, sir.
And then in the meantime, you can fill the other 3 seats.
Kelly Ward, and Trevor Trahan. Is that you? Okay, and then there's a Kenneth. A Kenneth?
Anybody named Kenneth in the room? Okay.
Okay, and then the other one is it's another signature that I cannot pronounce. It looks like, is it Lashonda? LLAS. Anybody else who signed a card who hasn't come up here yet? How about that?
Okay, come on up. Is that it? Is this?
Yes, sir. This
will be the
it.
final? Okay, great.
Well, from public comments, yes,
Right,
sir.
public comments, what I meant. Ma'am, if you want to go ahead and begin.
I certainly will. Thank you so much, and thank you for the opportunity. My name is Velva Bowles. I'm a physician scientist trained in Tulane. I worked in all 64 parishes of Louisiana. I'm here to say I'd love to see the subpoena go through. It is so important to include the people body in your decisions. Whatever incentives have been offered, and I've heard many, I hope people are in the first of that list. It's too important to have the opinion of us before you make a decision on what comes to Louisiana and how it affects our everyday life. As you know as well or better than I, Louisiana is at the bottom for healthcare and education and other things. And I would hope that in bringing business to this state, the negotiation is to elevate the income to the state as a whole and not just have a few benefit and not just have promises. I would like to think that all of you are scholarly and your negotiation and contracts, if it's on the behalf of the people, would be something proud you can tell us you've done. That there is no need for NDA, and by the way, thank you, it's good to know you've not signed one, because we need to know, and we should know. And as you being an elected official, you should want us to know. So thank you very much for this opportunity, and I look forward for the beneficence of this committee. Thank you.
Thank you, ma'am. Next speaker.
Good morning, Commissioners. My name is Lindsay or Rubia Garcia. I was the endorsed congressional candidate for the 5th Congressional District where the data center was going before they canceled the election, and now I am running in the 6th. And I came here today because I feel like this issue that's sitting right here is actually bigger than just Meta and the subpoena, but you all decided once again, just like in other things, not necessarily for the election, but decided to change the game the day of and along those lines. It's bigger than Entergy. Frankly, all of this is bigger than any particular data center and subpoena, as I said. This is about who this government is belonging to, because let's remember something fundamental. The government does not belong to corporations like Meta, does not belong to Entergy, does not belong to the governor, it belongs to the people, which is what I came here to say. And when government forgets that, the people have a responsibility to come here and remind you. We have been told over and over again about the jobs this project will bring. We have been told about the economic transformation. We have been told about the billions of dollars of investment. Entergy itself has championed the project as a win for Louisiana customers, pointing to the thousands of jobs and billions in investment. And I hope that this jobs line is true. I hope that the people of North Louisiana, all across Louisiana, benefit. But if it's such a tremendous deal for the people of Louisiana, then why has so much of the deal been kept from the people of Louisiana? Why the secrecy? Why the NDAs? Why shouldn't the people who are being asked to live with the consequences be allowed to see the information used to sell them on the benefits? We now know that Governor Jeff Landry personally signed an NDA with Meta's subsidiary, and this wasn't some obscure administrative document. The agreement restricted public disclosure not only of confidential business information, but even the existence of the agreement and the nature of the discussions. At least 54 elected officials have signed NDAs connected to major economic development projects under this administration, and now we're learning, according to the news articles that Mr. Poussin highlighted, we're learning that a sitting member of Congress, Julia Letlow, signed an NDA with Meta and subsequently bought Meta and NVIDIA stock with those trades disclosed more than a year late. I'm not standing here today declaring that those trades were illegal. I'm saying that the public has every right to ask the questions of the Public Service Commission. Because when elected officials have access to information that the public doesn't have and then trade securities connected to that information, the appearance of a conflict is not something we should simply shrug off. And yesterday we learned something else. An Entergy executive, its vice president of regulatory and public affairs, wrote or suggested changes to motions that came before this commission, allegedly including the motion approving the infrastructure for Meta's data center. Mr. Scametta, that's what Chairman Scametta, that's the motion that I was asking about, whether or not Entergy provided any information for some of the motions that have been presented.
Today?
Yes.
No, you saw we asked Ms. Evans to develop the motion sua sponte.
Well, I'm just saying publicly, it's being reported that it has been disclosed to you that there are entities. Well, perhaps you shouldn't reference it as a source of material if you're going to turn around and say, suffice to say, I'll get back to it's my time. Maybe there is an innocent explanation. Then give us the explanation.
You just saw us during this meeting ask Ms. Evans to develop the motion.
Then explain how the Sir, I'm going to get back to this. Is my time.
Go ahead. You have
Then give us the explanation. That's what transparency is for. Because here's the problem: when you tell the people, "Trust us, we're bringing jobs," while simultaneously keeping the terms of the terms, negotiation, projections, and supporting information behind NDAs and confidentiality walls, you're not asking for trust. You're demanding it from us. And government does not get to demand blind trust from the people it serves. The people of Louisiana are not shareholders in Meta. They don't have a seat in Entergy's boardroom. They do not get confidential briefings. They don't get NDAs. They don't get to negotiate the deal. We get the bill. So the people of Louisiana, especially the people who live in the communities directly affected by these projects, this message is also for you. You are not a nuisance. You are not an obstacle to economic development. You are not something to be managed after the deal has already been made. You are the sovereign. Your government is supposed to work for you. Your elected officials work for you. Your regulators and commissioners work for you. And corporations that want billions of dollars in public benefits, public infrastructure, tax incentives, and access to our communities should understand something. They don't get to bypass the people. Economic development is not a blank check here in Louisiana. A job is not a bribe for silence. An investment is not a substitute for accountability. And prosperity does not require secrecy. You took some of my time, sir. Thank you. If this project is as good for Louisiana as it champions it to say, then prove it in the day in sunlight. Show us the numbers, show us the contracts, show us the guarantees, show us who pays, show us who benefits, and most importantly, protect the people who are paying the price if something goes wrong. Because you folks are supposed to be the firewall between corporate power and the people, not the bridge between them. And commissioners, I want you to remember something else today. Your power is temporary. Every one of you sitting up there has a seat, but that seat does not belong to you. It belongs to the people here in this room and across Louisiana. The office and the authority doesn't belong to you. It's loaned to you by the people. And eventually, every one of you who holds public office has to give that power back. The pendulum will swing. I'll skip forward because I want to be fair. I believe in accountability, and it shouldn't be partisan. If it's Democrat, hold them accountable. Republican, hold them accountable. A corporation does it, hold them accountable. A regulator does it, hold them accountable, because that's what public service means. And if any of you sitting in these seats have forgotten whose seats they belong to, I have a simple reminder for you. Once again, they belong to the people, and the people have every right to flip your table, meaning each of your seats, if and when you forget the entire job is to serve us. How many of you are up for re-election?
Your time's expired. Next person?
No, not this time, just making sure.
Your time's expired.
That's why I'm running
Thank
for
you very
that one,
much.
that's why.
Okay,
Your
thank
time's
you, Ms.
expired.
Garcia.
Next speaker, please.
Mr. Trahan?
Hi, my name is Trevor. I'm a nurse here in Louisiana, and I've worked in healthcare for approximately 10 years. As a nurse, I have several concerns regarding this project and how it affects public health. And I believe that Louisianans should be included every step of the way, should not be kept in the dark, not only about widely what this project includes, but how it will affect our public health. Meta and Energy wish to keep the working class communities in the dark. And those working class communities are the ones who will pay for this project. Yet we don't know exactly what's on the table. We don't know how it affects public health. As Louisianians, we are tired of our state being used as a dumping ground. We are tired of our state being used to place projects that no one else wants in their backyard. And these are always placed within marginalized communities. Of these concerns, I will just simply quickly address three. So, draining water resources. Throughout the country, we see communities surrounding these data centers suffer with chronic water pressure issues, leading to water quality concerns, leading to persistent boil advisories. What about people with compromised immune systems who can't handle having water that might or may not be clean? Then we move on to noise pollution. So throughout the United States, communities across the United States that have these AI data centers near them report constant droning noises. This affects both mental and physical health. Lack of quality sleep is directly linked to increased mental health crises, to heart disease, hypertension, and increased risk of stroke. And then we move on to, lastly, greenhouse gases. What emissions will this project cause? There are 10 new natural gas plants on the table for this project. Will the government be tracking these emissions? How will we know? Increased air pollutants, of course, we know medically cause increased asthma, COPD exacerbations, long-term cancer concerns, and statistically, areas with more air pollution are linked to increased rates of early death. Surrounding farmland could be polluted. This could literally poison food for communities. And why is this relevant? Well, in healthcare, when we get a critical patient, it is our job as healthcare professionals to educate that patient on the risk of treatment and to weigh whether we risk the treatment that can be damaging and does it outweigh the damage to the patient. Which one's better? Why is that relevant here? Well, this commission stands to educate the public how this project could affect the public. What are the benefits? Because right now they're abstract. They are up in the air. They are in NDAs. They are in attorney only, possibly, we don't know that yet. But the public deserves to know. The public deserves to be able to weigh, is this truly beneficial? Do the benefits outweigh the risk to public health? It is our right to know these things.
Okay, thank you very much. You all are excused. Next speakers, please.
Black Power, all power to the people. So my name is Lucian Revel. I'm a grassroots activist and a social justice and human rights advocate. First question I have, is this motion about protecting legitimate trade secrets, or is it to prevent the public from seeing information necessary to determine who pays? How can the commission determine whether this project is prudent if the parties representing ratepayers cannot fully examine evidence? And I also got to say that I'm up here representing the black and brown poor communities, because right now we're seeing one of the biggest data centers being put right on side of the black community in Boise, and it seems like it's always on side of marginalized communities, especially the black community. So I got to come in and stand for my people, you hear me? What specific information claim is confidential? Is the confidential information related to Meta's projected electrical load, the electrical service agreement, collateral guarantees, construction costs, financial obligation, or something else? How can you independently verify energy in Meta's claim $2 billion in customer savings if the underlying assumptions are confidential? Which parties have access to the complete underlying calculations, and which parties are being asked to accept the saving estimate without seeing the underlying data? No answer. If Meta leaves if Meta leaves and reduces its load, and or delays construction, or changes business model, who absorbs the remaining costs? Do the public pay? Do the citizens pay? What percentage of the total net plant value is Meta actually required to secure today? If Meta's load disappears before these plants are fully paid for, who owns the stranded assets and who pays for them? Will energy be permitted to put those or remaining costs into the general rate basis and recover them from ordinary customers? For each one of the 7 proposed gas plants, what is the maximum daily water withdrawal in gallons per day? How many gallons are expected to be consumed rather than returned? What are the water resources for each facility? I'm asking for plant by plant numbers. Commissioners, if the public cannot see the information necessary to independently evaluate Meta's projected load costs, guarantees, and financial obligations, how can you tell Louisiana ratepayers that this decision is being made on a fully transparent, evidential record? It's not. It's not. Before you grant Meta an immediate review, will the commission identify on the record exactly what irreparable injury Meta claims it will suffer, and explain why that injury cannot be remedied through the normal final review process? And if their ruling concerns access to information needed by the public to evaluate ratepayers' risk, how does granting immediate review protect the public interest rather than simply protecting one-party interests? The LPSC's April decision already created an unusual accelerated procedure. That administrative hearing divisions was directed to compile the evidence record without a formal recommendation from the administrative law judge for the commissioners to consider, but the vote was 4-1, which Brother Destiny should have opposed it. So can y'all answer any of those questions? And in the last question I asked is, why is it put by the black community? We already got plants. We already got plants, carbon capture plants that we're dealing with, Creosote plants that we're dealing with. In history, it actually shows us that this is what always happened. Y'all put it right next to our community. Our people get sick. Our people are, because right now we've seen what our people in other states are developing COPD. Never had it, but now they got COPD, dealing with asthma and bronchitis problems. My question as a black man, as an African American in this country, dealing with oppression, redlining, and marginalization, is y'all trying to further push us to the ground, further step on our neck? Or is this really, I don't even got to ask if it's really for the people, because it's on side of our community. Anytime it's on side of our community, we know it's suspect. It's suspect, because y'all ain't come ask us. Nobody came talk to us about it. We knew nothing about it. It just popped up. And in history, that reflects something to me as a black man, my whole race and my people, and all marginalized people. That reflects something that y'all do not give a damn about us, our kids, our society, our community, or our conditions, or our future. Black power, all power to the people.
Thank you. Next speaker, please.
I think you made some excellent points.
I had a lot more. I just had to go ahead and let you go.
My name's Kelly Ward. I'm from West Feliciana Parish, part of your district, and I appreciate both you and your assistant Peggy Lathrop. I think
She does a great job.
She does a great job, answers our questions, clarifies things for us, and oftentimes will even clarify rumors that might be floated around. So tell her that we appreciate that.
Thank you.
We, trying to stay germane to the point, we in West Feliciana, as you know, have a data center that is being built right now. We've had a number of public meetings. We have our parish president and others have come and tried to explain everything going on with that project to the extent that they can. Some of the information they cannot comment on, and some of the information, especially early on, some of the information they don't have the answers to because they are not the decision makers. An example, in a meeting yesterday in our public library, Parish President Kenny Havard, in the presence of Julia Letlow, asked her the question, can you guarantee that the rates on our electrical rates for our citizens in our parish will not rise? Of course, that wasn't her jurisdiction. It's not the governor's jurisdiction. It's not Kenny Havard's jurisdiction. Whose jurisdiction is it? It is your jurisdiction. And so, how do you make decisions? How do you actually get down to the core decision making? You have information. You have clarity of information. You have transparent information. And to the extent that you can, you ought to seek that at all costs. Your administrative law judge has said they need to produce the evidence. We, the citizens, ask you to follow that guideline and follow that and vote for transparency. We need transparency in public service and public forums. These hearings are an example of transparency. People get up to say what they need to say. And we hope that you listen to what people are really interested in doing and interested and attentive to what we need to do. Why is it important to us? Let's be germane about it. If we don't have the information that tells exactly what the cost of energy will be to these plants, we can't make a decision about the efficacy of those decisions. If we don't know all of the factors that go into calculating the energy, that we might get a surprise meeting, or not a surprise meeting, but an agenda item on this docket that says, well, energy needs an increase to do this, that, or the other. Information is powerful. Transparency is powerful. We need transparency with this board and everybody else to the absolute extent your administrative law judge says yes, transparency, vote for transparency. We are asking you today, and each of your members, each of these meetings of this commission, vote for transparency. Let us know what's going on. We're intelligent people. We can make decisions. We can support decisions. But if you don't give us the information, and the information isn't shared with experts, people that first got up and spoke, how can we process information and make good decisions? One last thought. iPhone. Everybody has one, right? I'm on Facebook and a couple of other. Meta knows everything about me. Meta knows everything about you if you're on social media. I want to know everything about Meta.
Thanks.
All right. Thank you very much. Y'all are excused.
But I do want to say one thing before I get up. I hope y'all make the right decision, because y'all seen 2020 how we was out there when it's over us and concerning us. Unless you want us back out there, You want my people back out there, you better make the right decision, or you're gonna see all of us back out there.
Thank you.
Back power.
Appreciate it. That's it? Okay. All right. We have a motion on the floor by
Chairman.
Commissioner Kusan,
Mr.
seconded
Chairman.
by the chairman. We have opposition by Commissioner Lewis, and call the roll.
Mr. Chairman,
Yeah.
wait, I wanted to ask Mr. Marks from Meta about his motion before us.
That's not a motion from him, it's our motion.
I know, but I'm asking, can I call a witness to the table to question the
no.
motion that's beneath
No,
us?
we have a motion right now with
When
Commissioner
have we
Kusan.
never allowed to call a witness to the table about their own filing? It is his
It's not
filing
his
first.
filing.
He filed the motion for immediate review.
Not.
So we've taken it up, and I'm asking a question about his motion that he filed.
Procedural-
When have we ever done that? What procedurally what?
We have procedurally at the point where it is out of order.
It's never out of order. You
We
do this
have
all
a
the time.
motion. We have a motion. before
Mr.
the
Chairman,
floor.
that is disrespectful. I want to ask a question to a witness,
There
and
are
I'm
other
asking.
words to disrespectful. It is procedurally appropriate.
It is not procedurally
Catherine,
appropriate. It is not procedurally
I'm going
appropriate.
to ask our counsel, is it appropriate right now to go ahead and follow through with the motion as it's on the floor?
If there is anyone else who wishes to speak, or if the commissioners have questions.
We've always done
those
that.
Questions
Can
can
they
be
refuse?
answered.
Because Meta's not a party to this city.
He can come up and
I mean, they could refuse to answer questions.
I'm not on their payroll.
It looks
Please
like
calm
it.
down. Is that how it's going to
Okay,
be?
Yes,
guys, I need the
You wanna
public, I
disrespect me?
need
I'll
the
disrespect
Are you on the
audience to
payroll of the
not
Democratic
speak unless
Socialists of
you're at the
America?
mic.
Go.
Well, you had a breakfast for him this morning. Who paid for
I didn't have a
that?
breakfast for anybody.
It was
Thank
on.
you.
It's on your notice.
I had a breakfast for the Power Coalition.
Oh,
of Equity
yeah.
and
Well,
Justice. Get
there
it
you
right.
go. Well, you
Get
know,
it right if you want to call me
future
out. If you want to call me
That's
out,
right.
you better come with your facts.
Oh, I got facts. So
Yeah,
we'll
whatever.
see you. We'll see you in the next election cycle. Oh, I'm out. I'm out. So, even your staff is jumping up. There we go. So look, we're in a position right now to where we have to figure this out, okay? So let's understand where we are. Either we're going to look, does Meta has an opportunity? If they want to come up here and be presented, that's fine. The whole issue about this is Meta is not a party to this litigation. Okay?
Correct.
They are not a party to the litigation. That's what the whole issue is here. Okay? They are a non-party. Entergy is the party to this, right?
But they felt the motion.
Correct. That is a non-party motion.
That we are reviewing who filed
the attorney for the concerned scientist stated that it is a non-party motion to quash that they filed, and they were very
We're not on
clear
the
about that.
We're not on the
immediate
motion
review.
to quash.
All right.
On the
I'm
immediate
just trying to
Well,
keep the issue
I'll tell you what,
straight.
we'll solve this right now. Meta, if you want to come up, you can come up, or you can refuse.
I'm referring to, as stated, that was filed into the record on July 14th, 2026, enclosed, find the original copy of the non-party Meta Platform's motion for immediate review
That's what I
and
just
ruling and memorandum of law in support therefore of, submitted by Nelson Mullins, law firm by Weston Adams. That's the motion we're talking
The
about.
non-party motion is what I said, right? And that's
So
what you just
who-
referred to.
So he filed the motion for review, so I'm asking him a question about his motion to review.
And he can refuse to come up.
You didn't give him the opportunity to.
I just did. I said he can come up or he cannot come up. It's his choice. Okay, there we go.
Let's
All
call
right.
it. I'm good.
All right.
I'm done.
There we go. That's fine. Everybody's got a choice. All right? Y'all had a choice, he had a choice. Now, we have a motion on the floor by Commissioner Kusan, a motion seconded by the chair, and it is opposed by Commissioner Lewis, and we have a roll call vote requested by the chair.
Commissioner Lewis.
No.
No.
Commissioner Kusan.
Yes on my motion.
Commissioner Francis.
Yes.
Commissioner Scarpetta.
Yes. Matter's approved. We will take up the matter on.
Matter is not a.
Well, the matter is not, of,
Matter is not approved. The motion.
the matter is disposed of.
Yes.
They will take up the matter of the motion to quash at the September meeting. Okay?
So actually, your motion said that the motion to quash is rendered moot.
Oh, it's rendered
because
moot
we're
by
not
this?
issuing.
Okay.
You were reversing the
Okay,
decision
that's
to issue
fine.
the subpoena.
All right, that's fine. This is dealt with then. All right. we'll move on from here. We've got another one coming up on, this is Cantium, I think?
Yes, sir.
All right.
So
move on.
exhibit, I'm sorry,
This is 20, what?
28.
28?
So exhibit number 28 is docket number T37136. This is Cantium versus Rosefield's complaint against Rosefield for transportation and terminaling of crude oil as a common carrier without a tariff on file with the commission at rates that are excessive, and request that Rosefield pay reparations, refunds, and damages and charges for above just and reasonable rates. It's a discussion and possible vote. Guys, I need the audience to be quiet so the court reporters can get the public. You can leave, but please do it quietly. It's a discussion and possible vote on Rosefield's motion to amend the order number T37136-A to post a bond in lieu of escrow. It also is a possible executive session to discuss litigation strategy. This is at the request of the chair. At the April 2026 B&E, the commission directed staff to coordinate with Rosefield to establish an escrow account for all payments made since October of 23 to Rosefield by Cantium, as well as future payments. The amount to be put into the escrow account is difference between 67 cents and $2.50. The action was memorialized in order number T37136-A, which was issued April 24th of 2026. Rosefield timely filed a request for rehearing, which was disposed of at the commission's June B&E. While discussing the establishment of the ERA escrow account, Rosefield indicated that it had not segregated the required revenues from the escrow account and had used some of and will continue to need those revenues for capital and operating expenses to maintain its ongoing business operations. Given this, Rosefield sought to furnish a surety bond in lieu of escrow payment in order to comply with order number 37136-A. Rosefield filed the instant motion on August the 6th, seeking commission's authorization to post a surety bond in lieu of escrow, which is totaling approximately $13.7 million. Should the commission allow Rosefield to post a bond in lieu of escrow, Rosefield agrees to post the bond within 10 days of a commission order authorizing such action. Staff has had numerous conversations with Rosefield regarding the option of a bond, including reviewing and providing edits to the proposed surety agreement, and based on the information provided and independent research, staff does not oppose Rosefield's motion. It is staff's opinion that the bond accomplishes the commission's goal to provide security for both parties, as the amount in question is still pending commission review. Therefore, staff recommends that the commission amend order T37136-A to allow for the posting of a surety bond in lieu of escrow as a security for all past payments made between October of 23 and February of 26 by Harvest or Cantium to Rosefield above 67 cents per barrel, subject to Rosefield issuing the bond within 10 days of a commission order allowing the same.
Any motions on this? Hearing none? Matter is disposed of. Go ahead and make a motion for a hearing in September for a rule to show cause on, I believe you have the language on that, Catherine?
I do not have.
I talked to you earlier about rule to show cause, why the matter should not be dealt with under a contempt rule for failure to follow the commission's directive under the previous order.
May I speak and provide comments on behalf of Rosefield?
We just dealt, there was no motion supported, so it's dead.
I'm sorry. Ms. Bowman, may I
There was no one.
So if the commission does not take the action up, then there is no opportunity for public comment.
Okay, so then I'd like to just note for the record, I would like to speak on behalf of Rosefield in support of our motion. If I'm being denied that opportunity, it's
But no one made the motion. You didn't make a motion, a commissioner has to make the motion. There was no motion and no second.
Okay,
So
well then I apologize if I missed. I would like to motion I would like to make a motion for Rosefield's motion
No, I don't think you get to make the motion. It has to come from a commissioner. It's not court. It's commission.
Okay. Well, then I will just note that I would like the opportunity to speak, and if I'm denied the opportunity to speak, I acknowledge.
It's not, I mean, staff, you can tell her that it's not public comment if we didn't have a motion on the floor.
If an agenda item is not taken up, then public comment is not allowed on that item.
Okay, thank you.
Noted, thank you.
Okay.
Thank you.
All right, so you can put the rule to show cause on the September meeting.
And I'm sorry, just to be clear.
Oh, wait, you gotta press the button.
And to be clear for the record, I will just note Rosefield's objection to our motion not being taken up and the
It
notion
was taken
of...
up. It was taken up and was disposed of by not being dealt with. There was no vote on it.
Okay, I just object to it not being taken up and not granted, and to the matter...
Everything you're saying now is not going in the record.
Okay, well, I just want to preserve my objections.
This is not court. This is commission.
Understood.
Okay, thank you.
Thank you. And I just object to this suggestion that this will be considered for some form of
You
contempt
keep going on as
proceeding.
much as you want, but this is not court. This is not the same as litigation in court. This is a commission
I
hearing.
understand. Thank you.
Okay, thank you. All right, next item, please, which will be, I believe, 29. And I think this is rendered the same way as rendered moot, isn't it? Or do we have to bring it up? Let's bring it up and go ahead and deal with it. Well, 29.
So 29 is the same docket, T37136. It's a discussion and possible vote on Cantium's motion for sanctions at the request of the chair. It's the same factual background that I just made, and staff does not make a recommendation.
No motion. This matter is dismissed for failure to have a motion or a second. Next item, please, go back to the original docket. It would be exhibit number 2. You're good. Yeah, they're not. It's all on.
Exhibit number 2 is docket number 37797. This is the Commission versus Uncle Sam's Moving Corpse. It's a violation of 45-161 through 180.1 by engaging in activities related to household good moving prior to complying with the requirements of the revised statute 45-164E and General Order dated March 16th of 2021 for failure to comply with requirements of General Order dated April 3rd of 08 as amended. It's a discussion and possible vote on an ALJ rec. Staff investigated Uncle Sam's Moving Company and determined it was advertising moving services without being registered for the commission and issued a citation on December 1st, with the hearing being published in the commission's official bulletin for a hearing on March 5th. The carrier, Uncle Sam's, did not appear. Can we silence cell phones, please? After the hearing, this ALJ issued a recommendation on June 9th of 2026, finding that staff proved that Uncle Sam's is guilty as alleged and recommends staff's requested fine and fees. Based on the evidence admitted at the hearing, the ALJ's recommendation that the commission issue an order finding that Uncle Sam's is guilty of violating revised statute 45-164E1 by engaging in activities related to moving household goods intrastate through online advertising prior to complying with the requirements of the revised statutes and the general order. They're also guilty of the commission's 2008 general order by failing to include a common carrier certificate in its online advertising. The companies shall pay a $4,000 fine pursuant to 45-171 for its violations, as well as a $25 citation fee.
Move to accept staff recommendation.
Second.
Second by Commissioner Francis. Any opposition? No opposition? Motion so heard.
Exhibit number 3 is docket number T37833. It's the Commission versus Easy Movers alleged violation of revised statutes 45-161 through 180.1 by engaging in activities related to moving household goods prior to complying with the requirements of revised statutes 45-164E and Commission General Orders dated March 16th of 2021 and General Order April 3rd of 2008. It's a discussion and possible vote on a recommendation of the ALJ. Staff investigated Easy Movers and determined that they were advertising for intrastate household good moving services and not being registered with the commission. Staff issued a citation to them on January 21st of this year with notice being published in the official bulletin for April 2nd, 2026 hearing. The carrier did not appear. After that hearing and based on staff's evidence presented therein, the ALJ recommended that the commission issue an order finding that Easy Movers is guilty of violating revised statute 45-164E1 by engaging in activities related to moving household goods intrastate through online advertising prior to complying with the requirements of 45-164E1 and the 2021 General Order, as well as violating the 2008 General Order by failing to include commission certificate in its advertising, and that they shall pay a $1,000 fine pursuant to 45-171 and a $25 citation fee pursuant to 2006 General Order.
Move to accept staff recommendation.
Second.
Second by Commissioner Lewis. Any objection? No objection. Motion passes.
Exhibit 4 is T37879. This is the Commission versus Grade A Movers on alleged violation of Order T36679, revised statutes 45-161 through 180.1. by engaging in activities related to moving household goods prior to complying with the requirements of 45-164E and General Order dated March 16, 2021, and for failure to comply with requirements of General Order dated April 3, 08 as amended. Is a discussion and possible vote pursuant to Rule 57 on the affidavit and stipulation. As a result of an investigation by transportation staff, a citation was issued to the carrier on March 23rd of 2026. The owner of the company executed an affidavit and stipulation admitting to the violations and agreed to an imposition of a $2,000 fine and a $25 citation fee, with $1,000 being suspended, conditioned on the general agreements in transportation affidavits and stipulations. Staff recommends that the Commission exercise its original and primary jurisdiction under Rule 57 to consider the affidavit and stipulation and accept the affidavit and stipulation executed on June 11, 2026 for fines and fees totaling $1,025.
Move to accept staff recommendation.
Sorry, I need a Rule 57 first.
Move this to Rule 57.
Second.
Second by Commissioner Francis. Any objection? No objection. It moves under Rule 57. Motion to accept staff recommendation.
Second.
Second by Commissioner Lewis. Any objection? No objection. Motion passes.
Exhibit number 5 is docket T37908. It's the Commission versus Hornet Civil Services for alleged violation of 45-161 through 180.1 by operating intrastate without commission authority to transport non-hazardous oil fill exploration and production waste on 3 counts occurring on or about January 28th through January 29th of this year. It's a discussion and possible vote on a rule pursuant to Rule 57 on affidavit and stipulation executed by the carrier. As a result of investigation by staff, a citation was issued to the carrier on April 22nd of 2026 based on these allegations, and in response to the citation, the owner of the company executed an affidavit and stipulation admitting to those violations and agreeing to an imposition of a $25 citation fee and a $7,000 fine, with $3,500 of that being suspended, contingent on the standard conditions in the transportation affidavit and stipulations. Staff recommends that the Commission first exercise its original and primary jurisdiction under Rule 57, and then second, accept the affidavit and stipulation executed on July 21st of this year for fines and fees totaling $3,525.
Motion to move under Rule 57. Second by Commissioner Francis. Any objection? No objection. Motion to accept staff recommendation. Second by Commissioner Lewis. Any objection? No objection. Motion passes.
Exhibit number 6 is docket T37948. This is the Commission versus Tiger Totes on an alleged violation of 45-161 through 180.1, engaging in activities related to moving household goods prior to complying with the requirements of the revised statutes and general orders dated March 16th of 21, as well as April 3rd of 2008. It's a discussion and possible vote pursuant to Rule 57 on that affidavit and stipulation. As a result of an investigation by staff, a citation was issued, and the owner of the company executed an affidavit and stipulation admitting to the violations in that citation. The carrier agreed to the imposition of a $25 citation fee and a $1,000 fine, with $500 of it being suspended, contingent on the standard conditions and agreements and transportation affidavits and stipulations. Staff recommends that the Commission first exercise its original and primary jurisdiction under Rule 57, and second, accept the affidavit and stipulation executed on July 30th for fines and fees totaling $525.
Motion to move under Rule 57. Second by Commissioner Francis. Any objection? No objection. We move to Rule 57. Motion to accept staff recommendation. Second by Commissioner Francis. Any objection? No objection. Motion passes.
Exhibit 7 is T37949. It's the Commission versus College Boxes on alleged violation of 45-161 through 180.1 by engaging in activities related to moving household goods prior to complying with the requirements of the revised statutes and Commission general orders of March 16th of 2021 and April 3rd of 2008. It's a discussion and possible vote pursuant to Rule 57 on an affidavit and stipulation. As a result of an investigation by staff, a citation was issued to the carrier, and the carrier executed an affidavit and stipulation admitting to the violations and agreeing to the imposition of a $25 citation fee and a $1,000 fine, with $500 being suspended, contingent on the standard conditions in transportation affidavits and stipulations. Staff recommends that the Commission exercise its original and primary jurisdiction under Rule 57 and accept the affidavit and stipulation executed on July 15th for fines and fees totaling $525.
Motion to move under Rule 57. Second by Commissioner Francis. Any objection? No objection. Move under Rule 57. Motion to accept staff recommendation. Second by Commissioner Lewis. Any objection? No objection. Motion passes.
Exhibit number 8 is docket R 37339. It's the Commission's proposed amendments to Commission General Orders dated April 21st, 1999, November 8th, 1999, April 25th, 2012, March 16th, 2021, and supersede General Order dated May 30th of 2008 and October 13th of 2023, as well as establish rules for transporters of waste and salt water to coincide with recent amendments to intrastate motor carriers insurance requirements. It is a discussion and possible vote on staff's recommendation on final rules. Staff did these rules to codify all insurance for transportation carriers into one rulemaking. These rules adopt definitions for various classifications of motor carriers and specifically codifies them therein, maintains the historical distinction between common and contract carriers, places all minimum insurance requirements for all classifications into one rule, identifies the specific type of insurance is required for each, provides the Commission's filing requirements for insurance purposes, provides a classification for dispatch taxi cabs, removes the motor carrier's ability to self-insure, and provides set standards for minimum insurance and violations that could be assessed should a motor carrier not adhere to the Commission's rules. Staff recommends that the Commission adopt staff's recommendation on final rules filed into the record on August 4th of this year.
Any comment on this?
Just one question.
Sure, go ahead.
Thank you, Mr. Vice Chair. Just a question for staff. I know we are eliminating the ability for self-insured carriers, and so I'm just curious on what will that transition period be and how long will those who are common carriers who self-insure have to come into compliance with this now requirement?
Sure, and I'll let Ms. Burrell correct me. My appreciation is those that are self-insured currently with us, and there's very few. I think it's
Maybe 4 or 5 at the most, 2. Okay, it's less than I thought, okay.
They have to come in every year, and I believe it's June or July, to provide us the information and prove that they in fact are self-insured. So if this rule passes today, we would allow those 2 carriers the entire rest of 2026 to summer of 27 in order to get insurance to come into compliance with the new rule.
Okay, great, thank you.
So we're on, that was Exhibit 8?
Yeah, Exhibit 8.
Has it been voted on?
No, we have a motion. I'm making a motion to accept the staff recommendation.
Seconded? Second by the chair.
Any objection? No objection. Motion passes.
Okay, I'll take over for Exhibit 9, please.
Exhibit number 9 is docket number S37855. This is DIMCO's request for letter of non-opposition authorizing financing of construction. It's a discussion and possible vote on staff report and recommendation. On February 24th of this year, DIMCO filed the instant request pursuant to the Commission's General Order dated March 18th, 1994, seeking authorization to enter into a loan agreement with CoBank for $20 million. The proceeds will be used to pay for or reimburse a project, including construction costs, related professional services, and other project-related costs permitted by those loans. The request was published in the Commission's official bulletin, and no interventions were received. Based upon the information received, staff concurs that the transaction is in the public interest and has no immediate effect on rates or terms of service for DIMCO's members. Staff recommends that the Commission express its non-opposition to the request, subject to standard conditions for issuing non-oppositions for loans.
I have a quick question for council on this from the company.
Okay.
And I'll make a motion to accept staff recommendation, but I do want...
I'll second.
And a second from Commissioner Kusan, but I got a quick question.
Hey, Carrie Cantro, on behalf of DIMCO, I have
You
with
might
me...
have to pull it closer to you.
Yep, no problem. I have with me Mr. Mark Phillips, the new CEO, and I'll take this opportunity to introduce him to the Commission. Mark has been with DIMCO for over 25 years, started as a lineman, and he's taken over for Mr. Randy Pierce, who we were very happy to have, but we're also very excited to have Mark. And then also with me is Nick, the Director of FP&A at DIMCO.
Great, thanks. This really goes back to a conversation we had in pre-meeting about the issue about this particular loan. And we talked also about the formula rate plan, about how there was going to be a sort of a negligible impact on rates for the DIMCO customers. My question to you was, with a $20 million loan that over the lifespan is probably going to cost $40 million, how it's going to not be an additional $40 million to the cost of the company, and how it's not going to be a rate impact at some point. So if it's not going to be a rate impact now, when is it eventually going to be a rate impact?
That's a fair
Because
question.
between the $200 million cost of the battery that was voted on to pay back Nextera, which is a payback on DIMCO customers, as well as this potentially $40 million total value cost over the life of the loan. When is this actually going to come into play about really becoming a rate impact?
Right, I think that's a good question. The $20 million, to clarify for the battery, that wasn't a loan. That was a PPA that we did with NextEra. This loan, interest and the payback is taken as you draw money out. I think why we say there's no immediate impact, because the financing itself doesn't have a rate impact, but yes, you're correct.
You need to pull that microphone closer.
As we start pulling money out.
I'll pull it to you, it doesn't have a cord. There you go.
As we start pulling money and drawing money down off the loan, as well as when the interest starts picking up, yes, there's an impact. And we got with staff in the data responses and responded that it was about probably, Nick, correct me if I'm wrong, $1, well, initially very little, but over the course, if you draw the full $20 million out, $1.30 if you don't refinance and over the course of the loan.
Okay,
Per customer.
so when is that going to come into play? When are y'all going to start drawing on it? Just so I know.
So we would start drawing on the loan in 2026 when we start construction, but it wouldn't fully hit rates until the 2027 year, because that's when our 2026 formula rate plan test year.
And that'll be part of the formula rate plan in 2027?
That's correct. Our filing in 2027.
So in 2027 will be when this dollar plus unit may come into play on your rates?
When we file our annual reports with the commission, it will be part of that reporting. So I think that immediate rate impact discusses, like as of today, tomorrow, no. But when we come in and we file everything with you all for that yearly checkup on our rates,
right,
you'll see it then.
Yeah, because I just want to be realistic about this, is you're saying no rate impact and you're borrowing $20 million, which is really going to be $40 million with interest. It is going to be a rate impact, but it's just nice to talk about what that rate impact will be when it does happen.
No, I think that's fair. And I think with the interest, it might be 35, was it?
It's about 35 million with
Well,
interest.
I just did it with, monkey math. I didn't do it with a
you're
calculator.
good.
Right. So
and then that $1.30.
I just ran it in my brain real quick. So before it's over, trust me, it'll be 40 before you blink. But look, thank you very much. I think that answers all my questions, Commissioner Lewis.
Thank you, Mr. Chairman. Just for clarity, can you tell me what are the terms of the loan and how many years that we're?
It's a 20-year loan.
20-year loan?
Yes.
Okay, thank you.
You're welcome.
I think that's it.
I appreciate it.
We have a
Thank you,
motion on the
guys.
floor, seconded by the chairman, seconded by Commissioner Kusan. Any opposition? Hearing none, matters approved. Next item, please.
Next item is exhibit number 10, which is docket number S37903. It's Brightspeed of Louisiana and Brightspeed of South Arkansas's request for a letter of non-opposition to the pro forma transfer of certain assets to affiliates of Brightspeed of Louisiana and Brightspeed of South Arkansas. Discussion and possible vote on staff's report and recommendation. On April 17th, the Brightspeed companies sought an order from this commission authorizing a complete pro forma transfer of certain assets, including customer contracts and related telecommunication network facilities from Brightspeed Louisiana and Arkansas to their affiliates. The pro forma transfer is part of a new financing initiative by the parties and their affiliates to support the continued deployment of fiber connectivity through Louisiana and other states, promoting fiber deployment to rural and underserved areas of Louisiana. It was published in the Commission's official bulletin and no interventions were received. Staff recommends that the Commission express its non-opposition to the request, subject to the conditions contained in staff's report and recommendation, which were filed into the record on July 13th of 2026.
Chair moves to accept staff recommendation. Any seconds? Second. Seconded by Commissioner Lewis. Any opposition? Hearing none, matters approved. Next item, please.
Exhibit number 11 is docket number S37940. It's Southwest Arkansas Telecommunications and Technology doing business as 4 states fibers, petition for partial relinquishment of designation as an ETC in Louisiana. It's a discussion and possible vote on staff's report and recommendation. On May 26th of this year, 4 States Fiber filed this petition with the Commission, and it was published in the bulletin with no interventions. 4 States Fiber is a wholly owned subsidiary of Southwest Arkansas Electric Cooperative and is receiving Rural Digital Opportunity Funding Phase 1 auction to deploy in Arkansas, Oklahoma, and Louisiana. They were granted the ETC designation in the census blocks that the Commission following the conclusion of the Phase 1 auction. 4 states has now faced multiple setbacks trying to meet those RDOF obligations in Louisiana with significant extra costs, such as spending $4 million just to conduct title searches. This is the reason why 4 States Fiber has decided to partially default on its RDOF award in Louisiana and in Arkansas and terminate its efforts to bring high-speed broadband and voice services into the areas. Staff recommends that the Commission accept the staff's report and recommendation filed into the record on June 26 of 2026, which authorizes the partial relinquishment.
Chair moves to accept staff recommendation. Any seconds?
Second.
Seconded by Commissioner Francis. Any opposition? Hearing none, so ordered. Next item, please.
Exhibit number 12 is docket number S37960. This is Point Capee Electric Membership Corporation and 1803 Electric Cooperatives joint petition for full membership status of Point Capee Electric membership into 1803 and other relief. Is a discussion and possible vote on staff's report and recommendation. This petition was filed by the joint applicants on June 15th of this year and was published in the Commission's official bulletin, with MISO doing an interested party filing and Entergy filing a petition for intervention. The petition sought Commission order finding that it was reasonable in the public interest for Point Capee to become a full member, allowing it to participate as a wholesale member, as well as finding that the wholesale power contract between the two parties was reasonable, that Point Capee's IRP requirements would be satisfied by becoming a full member, and that the 1803's management of Point Capee's electric wholesale power agreements would be reasonable in the public interest. Staff filed its report and recommendation into the record on July 28th of this year, and in the opinion of staff, subject to affirmative obligations of prudent management by 1803, the requested relief is in the best interest of ratepayers and members of both parties. On July 29, 2026, a joint applicants filed correspondence in the record indicating that they accepted the staff report and recommendation. Staff recommends that the Commission accept the staff report and recommendation, including the conditions therein, filed into the record on July 28th of 2026.
Chair moves to accept staff recommendation. Any seconds?
Second.
Seconded by Commissioner Francis. Any opposition? Hearing none, the matter is approved. Next item, please.
Exhibit number 13 is docket number S37962. This is Concordia Electric Cooperative and 1803 Electric Cooperative's joint petition for approval of transfer of transmission facility assets by Concordia Electric Cooperative to 1803. It's a discussion and possible vote on staff's report and recommendation. This petition was filed on June 16th of this year, published in the Commission's official bulletin, with MISO filing as an interested party and Entergy filing for intervention. The petition sought the approval of the transaction between 1803 and Concordia pursuant to the Commission's March 18, 1994 order approving the transmission and distribution services contract between the parties, finding that 1803 and Concordia have complied with the Commission's general orders and requirements, declaring all the costs associated with the transaction be deemed eligible for rate recovery. And on July 28th of this year, staff filed its report and recommendation, finding that subject to the affirmative obligation of prudent management by 1803, the requested relief is in the best interest of the ratepayers and members of both Concordia and 1803, subject to the standard conditions and assets of transfers. Staff recommends that the Commission accept staff's report and recommendation filed into the record on July 28th of 2026, including the conditions contained therein.
Chair moves to accept staff recommendation. Any seconds?
Second.
Seconded by Commissioner Lewis. Any opposition?
Let me comment.
Yes, sir.
Please. We've had some reliability issues in this area, and talking to all the principals here, I feel like with 1803 could possibly help with the reliability report. Add that into the record. Thank you.
Yes, sir. There are any opposition to? I have a motion and a second. Any opposition? Hearing none, the matter is approved. Next item, please.
Exhibit number 14 is docket number U37769. This is Jefferson Davis Electric Cooperative's petition for determination of its facilities as transmission facilities and approval to transfer functional control to MISO. It's a discussion and possible vote on an uncontested stipulated settlement. On October 30th of 2025, JDEC filed the instant application, which was published in the Commission's official bulletin, and Entergy Louisiana intervened, with MISO filing to be included as an interested party. In its application, JDEC requested that certain filings qualify as transmission assets under FERC's 7-factor test, that functional control of those facilities be transferred to MISO, and that the transfer satisfies the Commission's general order dated March 18th of 1994. On June 24th of this year, the parties entered into an uncontested stipulated settlement, filed into the record. The major terms of the settlement are that the parties agree for the sole purpose of this application and this proceeding that the Commission does not object to MISO considering all of the facilities as transmission facilities pursuant to FERC's 7-factor test. JDEC has not requested approval of the O&M agreement attached to its testimony. Thus, that agreement has not been reviewed for prudence or other concerns and is not addressed in the stipulation. JDEC does not seek approval of a sale or conveyance of the facilities, and under this stipulation, JDEC will retain ownership of the facilities while MISO exercises functional control. JDEC shall not transfer the ownership of facilities in the future except in compliance with the stipulation therein. Staff recommends that the Commission accept the uncontested stipulated settlement filed into the record on June 24th, 2026.
Chair moves to accept staff recommendation. Any seconds?
Second.
Second by Commissioner Francis. Any opposition?
Chairman.
Yes, sir.
We had a PowerPoint presentation to show the improvement in the Cameron Parish this new line, and because of the heavy load here today, we decided to put it off till next month, but, we're really proud of that line and what all the work's been done. It'd be great for people to see the before and after of the, and, don't really like all the shots of the hurricane damage, but, it's part of living in Cameron Parish. So, stay tuned, next month, we'll show the slide picture.
If you'd like to, I mean, we have a link that JDEC provided to us. We can put that up on the website as
great.
well, a link to it. I think I have the capability of doing that.
All right, okay. All right.
I'm looking at IT,
There you
yes?
go. Yeah,
Sure,
you do.
yeah, okay.
You're our tech guy,
There you
okay.
go. Anyway, we have a motion and a second, and any opposition? Hearing none, the matter is approved. Next item, please.
Exhibit number 15 is docket number U37775. It's L&R Utilities application for an adjustment in retail rates for water and wastewater and request for a letter of non-op to borrow funds for capital improvements. It's a discussion and possible vote on an uncontested stipulated settlement. On October 31st of 2025, L&R filed the instant application, which arose as a result of needed capital improvements such as new water source and current rates being insufficient to cover the operating cost. L&R also requested a letter of non-opposition to borrow up to $3.7 million for water system improvements at an interest rate not to exceed 2.45% and an amortized period not to exceed 20 years, and borrow an additional $1.1 million for wastewater system improvements at an interest rate not to exceed 9% and an amortization period of not to exceed 15 years. Notice of the request was published in the Commission's official bulletin and no interventions were received. Staff and L&R agreed to a settlement in this proceeding with the major terms as just outlined. Staff recommends that the Commission accept the uncontested stipulated settlement filed into the record on July 6th of 2026.
Chair moves to accept staff recommendation.
So, this is in Foster Campbell's district.
Yes, sir.
And I'm very familiar with it also.
Yes, sir.
And, did you make a motion?
I did. Would you like to second
I'd
it?
like to second it.
Okay, thank you very much, sir. The matter has been moved and seconded by Commissioner Francis. Any opposition? Hearing none, the matter is approved. Next item, please.
Exhibit number 16 is docket number U37792. This is Pierre Part Natural Gas application for extension of a rate stabilization plan. It's a discussion and possible vote on an uncontested stipulated settlement. On November 19th of 2025, Pierre Part filed the instant request, which was published in the Commission's official bulletin with no interventions. Commission Order U35038 authorized the establishment of Pierre Part's RSP with a 3-year term, and then I'm looking for the ROE, sorry, with a target ROE of 10% with 50 basis points around it. At the completion of discovery and submission of testimony in this docket, Pierre Part and staff reached an agreement and executed an uncontested stipulated settlement, which was filed into the record on June 29th, 2026, which allowed the RSP to continue for another year. The Pierre Part would also make a revenue-neutral tariff change to its increase the monthly service to $15 and reduce the commodity charge according to the revenue expectations. Staff recommends that the Commission accept the uncontested stipulated settlement filed into the record on June 29th of this year.
Chair moves to accept staff recommendation. Any second?
Second.
Seconded by Commissioner Lewis. Any opposition? Hearing none, the matter is approved. Next item, please.
Exhibit number 17 is docket number U37793. It's South Coast application for extension of a rate stabilization plan and is a discussion and possible vote on an uncontested stipulated settlement. November 19th of 2025, South Coast filed its instant application. It was published in the Commission's official bulletin and no interventions were received. Order number U36276 authorized the extension of South Coast original RSP for an additional 4-year term, with those terms ending in 2025. Staff and South Coast entered into a stipulated settlement agreeing to an extension of the RSP, which was filed into the record on June 29th of 2026. Therefore, staff recommends that the Commission accept the uncontested stipulated settlement filed into the record on June 29th of 26.
Chair moves to accept staff recommendation. Any seconds?
Second.
Seconded by Commissioner Francis. Any opposition? Hearing none, the matter is approved. Next item, please.
Exhibit number 18 is DEMCO's Formula Rate Plan Annual Report filing for the test year ending December 31st of 2025. It's a discussion and possible vote on a joint report and draft order. On March 2nd of this year, DEMCO filed its annual report filing, which was published in the Commission's official bulletin, and no interventions were received. Commission Order number U37392 established the current FRP rider, which provided a calculated times interest earned bandwidth of 1.4 to 1.6. DEMCO calculated in this filing a calculated tier of 1.88. which resulted in a revenue decrease of approximately $2.3 million. Commission staff conducted a review of the filing and recommended no further adjustments. The parties filed a joint report and draft order into the record on July 1st of 2026, acknowledging the resolution of all issues. Therefore, staff recommends that the commission accept the joint report and issue the draft order filed into the record on July 1st of this year.
Chair moves to accept staff recommendation. Any seconds?
Second.
Seconded by Commissioner Lewis. Any opposition? Hearing none, the matter is approved. Next item, please.
Exhibit number 19 is docket number U37862. It's Parish Water Company's formula rate plan for test year ending December 31st of 25. It's a discussion and possible vote on a joint report and draft order. On March 2nd of this year, Parish filed its annual report, which was published in the Commission's official bulletin with no interventions. Order number U36540 provided the implementation of the formula rate plan with test years ending for 2025. Staff's report and recommendation was filed into the record on May 5th of 2026. It found that an adjustment in rates was necessary to increase Parish's FRP revenue by approximately $764,000. On June 10th, the company filed formal response indicating it agreed. Staff recommends that the commission accept the joint report and draft order filed into the record on July 9th of this year.
Chair moves to accept staff recommendation.
Second.
Seconded by Commissioner Kusan. Any opposition? Hearing none, the matter is approved. Next item, please.
We have disposed of Exhibit 20, so we are moving to Exhibit 21, which is docket number U37887. This is Atmos's Rate Stabilization Plan Annual Report for the Louisiana Division for test year ending December 31st of 2025. The discussion and possible vote on a joint report and draft order. On March 31st of this year, Atmos filed its annual report for test year 25, and it was published in the Commission's official bulletin with no interventions. Sure. In order number U36658, the Commission adopted the terms and conditions for a renewal of the RSC, specifically with an overall ROE of 9.8%, with earning bandwidth of 20 basis points. In the 2025 filing, Atmos reported an ROE of 6.54%, and the Louisiana Division required an increase of approximately $38 million prior to the company's amortization of EDIT and amortization of state tax liability. Based upon those adjustments, the overall revenue increase reduced to gross increase of $34.4 million. Staff conducted a thorough review and found that those adjustments were necessary. On July 20th, Atmos filed an addendum to their correspondence indicating a couple of additional changes, which would also reduce Atmos's revenue increase to a total of 33.7. The parties filed a joint report and draft order into the record on July 23rd of 2026, which acknowledged the resolution of all issues, and as such, staff recommends that the Commission accept the joint report and issue the draft order filed into the record on July 23rd, 2026.
Chair moves to accept staff recommendation. Any seconds?
Second.
Seconded by Commissioner Francis. Any opposition? Hearing none, the matter is approved. Next item, please.
Exhibit number 22 is U37894. This is Point Capiz Formula Rate Plan Annual Report filing for test year ending on December 31st of 2025. It's a discussion and possible vote on a joint report and draft order. On April 1st of 2026, Point Capiz filed this test year annual report, which was published in the Commission's official bulletin, and no interventions were received. Order number U37341-A established Point Capiz modified debt service coverage ratio bandwidth of 1.75 to 1.95. And in this current filing, Point Capiz reported a MDS of 1.81, and as such, the ratio falls within the bandwidth, and therefore there is no need for adjustments. Commission staff conducted a review and found no further adjustments needed. The parties filed a joint report and draft order into the record on July 6, indicating such. Therefore, staff recommends that the Commission accept the joint report and issue the draft order filed into the record on July 6 of this year.
Chair moves to accept staff recommendation. Any seconds?
Second.
Second by Commissioner Lewis. Any opposition? Hearing none, the matter is approved.
Exhibit number 23 is docket number U37912. This is Louisiana Water Company's formula rate plan for test year ending December 31st of 2025. It's a discussion and possible vote on a joint report and draft order. On May 1st of this year, ALACO filed its annual report pursuant to the provisions of Commission Order number U37760. The filing was published in the Commission's official bulletin, and no interventions were received. Staff's report filed into the record on June 30th of this year determined that with LawCo's adjustments and several additional adjustments to operating expenses, LawCo earned a ROE of 7.51 during the 2025 test year, which fell below the 9% lower earnings bandwidth prescribed by the Commission's order. And accordingly, the implementation of a rate increase of approximately $423,000 was warranted. The company agreed with that. Staff recommends that the Commission accept the joint report and draft order filed into the record on July 20th of 2026, and we do have one yellow card for this one.
Correct, and we'd like to invite that gentleman to come up. Commissioner Francis would like to invite them to come up.
My office is downtown Crowley, and we're in this water district, and I'm proud to have our mayor and some of our city council here. Y'all come up here a minute. We're going to show you all off. Where's the council? Come on up, council. And this is, although I live outside of town, every time I get a drink of water at the office, it's LawCo water, and you guys are affected by that. Y'all have a seat right quick.
Ladies may sit.
Won't you go ahead and announce yourself, who you are, and start with you, Mayor?
Yes, sir. Mayor Chad Monso with the City of Crowley.
All right. Ladies?
I'm Sandra Marks, Mayor Pro Tem, Alderwoman, Ward 2.
I am Katie Chasson, and I am Alderwoman for Ward 1.
Brad Core, Alderman, Ward 2. Chuck Ashby, Alderman at Large.
And so the election is this fall for the replacement or re-election. And one of the things that impressed me about your group is, I understand like 5 that are unopposed.
Yes.
And although I think the mayor's being opposed, but
These 4 are the ones unopposed.
Okay, but he's a leader. I think my compliments to you for you got a good team there.
We do.
But I know that the city of Crowley has the wastewater system.
Yes, sir.
But the drinking water is potable water is LawCo.
That's correct.
Most people in town think that y'all regulate all of it, and so I don't get that many calls at my office.
I get them for you.
Anyhow, we thought this was really an interesting situation, but a lot of people weren't that happy. We've had some problems with the water in Crowley, and that's why I asked him to come up here today. And I don't know if I could kept him from coming or not, but you need to have your day in court. So your people need to know that you're here taking up for their water rights, even though we regulate it. You get all the complaints.
Yes.
But Mayor, tell me what's going on, and have you talked to the water people about the problem?
Yeah, so commissioners, thank you all for having us here today. We appreciate the opportunity. As mentioned, I am the mayor of the city of Crowley, and we do not own the water system. Many municipalities of our size do own the water system, but our city only has wastewater. We only own the messiest utility, I guess you will. And so, we've had, look, I retired after 20 years of being a firefighter in the city of Crowley. I'm no stranger to working with LawCo, and we certainly have a great working relationship, and that continues today. But, people will complain about their utility bills often. I'm one of them. I don't want to pay the high utility bills either.
You need to call your commissioner.
We do, yeah. I'm gonna go visit him. But we do have to pay those bills, and so we see that. I see those complaints often on social media, and so I try to explain to people even a small leak in your toilet or a drippy faucet could certainly cause your bill to rise. And this last incident seemed to be quite a bit more than that. And we've gotten multiple complaints, and I was able to collect many. What I did was I called LawCo, or I sent an email out to the local guy and asked for a meeting. And I asked that some of the managers or the movers and shakers within the company out of Baton Rouge would be there also. And I met with 3 of them, individuals, the local in Crowley and 2 from what I thought was Baton Rouge. I'm understanding maybe they were from Iberia now, and questioned these bills. And probably the elderly lady who kind of started the mission of finding out what happened. I have her most current bill here, and she had since November, and I'm assuming it's a new service in October, because it just the usage history starts in October. And November of 25 was 29 units. 1 unit is 100 gallons. December of 25 was 24 units. 26, 22, 23, 31, 25, 26 in June of 26. And then in July of 26, it went to 206 units. And August is back down to 31 units. 206 units times 100 is what?
A lot of water.
A lot of water. She didn't have a swimming pool in her backyard. She did not, because last month when she got the July bill, our code enforcement, of course, they started calling City Hall. Our code enforcement officer went out, helped her, looked at her bill, looked around her house for water leaks, even looked at her meter, which was not turning, made sure everything was off in the house and the meter was not turning. Sat there and talked with her a little while, kept looking at the meter, and found that she had no leak. And then August bill went back to normal. So a lot of these bills had been discussed in this situation. And when we met with LawCo, one of the possibilities were that they estimated bills for 2 to 3 months, depending on where you were in the city, because not all customers are read at one time, and so there's different zones and whatnot. And so it could have been 2 to 3 months for some customers that they estimated the water bill. And this is a result of actually having a meter reader now, and that meter reader going out and reading the meter. That result is said to have been a possible leak within the 3 months of estimating. Again, I have this bill that obviously there was no leak. And also I've had people tell me that they didn't have a leak. Now, take that at face value. Maybe they're not telling me the truth. But I also just looked at a bill, because I didn't see all of them. We still get them in at City Hall. But I just looked at a bill that had 90,000 gallons of water billed, $1,300 for the water bill. Now, that total cost includes sewer user fees. So understand that not $1,200 for 90,000 gallons of water, that includes the sewer user fees with that, but 90,000 gallons of water is the real situation. And code enforcement and the LawCo employee went visit with this lady, and she admitted that she had a leak fixed under her back porch. And I just called my code enforcement guy, and he said, yeah, she admitted that she had a leak fixed, and she said it was a gasket that had to be changed.
Okay, so I guess we did the right thing.
I don't know how 90,000 gallons of water could leak from the back porch of a residential lot, whether the gasket was gone or the pipe was disconnected. That's larger than many swimming pools in backyards. 50, 60,000 gallons for a regular swimming pool, in-ground swimming pool, 70,000 gallons, pretty big swimming pool. I can't believe that this resident allowed 90,000 gallons of water to leak, even if it was spread over 3 months. not to rub salt in the wound, but I used AI recently and asked what 90,000 gallons would look like on a residential lot, 75 by 100. And one of the answers was, if it was able to be contained on that lot, it would be 19.5 inches of water throughout that entire lot. If not, certainly neighbors' yards would have water in it, and this is over 3 months. It just is unbelievable to me that that's possible. Now, to be fair, I didn't like the answers that LawCo gave me in that meeting. I had not called Commissioner Francis's office yet. I wanted to deal with it with LawCo. And when I did not get what I thought was honest answers and good help, then I called Commissioner Francis's office, and that's why we're here today. Since then, LawCo has reached out to me, and a couple of them are here today and spoke with me in the hallway today also, and I appreciate that. But the questions I have are still at hand. One, how long has LawCo been estimating bills? You can't tell me 20,000 gallons of water in 1 month or in 3 months were billed to this lady when she did not have a leak, and it was only 3 months of estimating. I don't believe that. I cannot believe that. You can't tell me that the 90,000 gallons, if it was only 3 months of estimating, that 90,000 gallons of water leaked out of this lady's.
What was the what was the charge on the 90,000, the one that you did?
I don't know what the just water charge was, the full bill with sewer user fees. Now, I understand sewer user fees in the city of Crowley is 24 base, $750 for 1,000 above, every 1,000 above 2,000.
Mm-hmm.
So we could figure that out real quick with a calculator.
It was a couple hundred or a couple thousand?
Oh, no.
It
was $1,200 total.
Total over 3 months?
Probably about $500 or so for water, because again, at $750 for every 1,000 above 2,000, that sewer user fee starts calculating pretty high.
Think there was a malfunction of the meter?
I don't know. I don't know. But how long has it been being estimated? How did this happen?
That's something I want to address. Commissioner Fry, do we allow utilities to estimate?
Generally speaking, no, Commissioner. In our water and wastewater regulations, there is language about prohibiting estimating meters unless there are essentially exigent circumstances. I mean, one example I think of is, I think we hit the 10-year anniversary of the 2016 flood, where you had debris in the Lafayette area and the Baton Rouge area. Just essentially, you couldn't get to a meter. So there was no way to actually read a meter in that scenario, and waivers were granted. But no, the general rule is you cannot estimate.
Well, also,
Commissioner,
I'm very fond of.
Can you bring your mic closer?
I'm very fond of smart meters, automatic meters, and if you had a situation like that, you'd have an alarm pop up to warn us. I understand some of the neighboring towns have smart meters already.
Absolutely, yes.
And,
yes.
I'm going to look into that with LawCo and be talking to you guys. But there's still some of these issues need to be resolved. If you and LawCo can't make peace by the time of the next meeting, I'll get involved and
Yes, sir.
help straighten it out.
To be fair, LawCo has issued multiple credits, and they have offered to issue credits to accounts with these excessively high bills. I think they're probably over 100 or a couple of hundred accounts now that they've shown me outside that they have credited. I certainly can't and shouldn't have to go to these customers and say, hey, if you got a high water bill, call LawCo. And I think they're working on that now.
Yeah.
But our citizens, they deserve an explanation, and they need to know what happened here and why did it happen, and what are we going to do going forward to prevent it from happening again.
Well, To start with, you give them my phone number. Tell them they got
Yes.
the wrong number.
I'll do that.
This happens with the Louisiana legislature all the time, and we call them, we're in charge of that.
Yes.
So I'm still in charge, and
Yes.
if they can't get right with you, and let's get some options going, and I think you should ask them, tell them we need smart meters. That's what I'm gonna tell them. That'll probably help.
I asked, obviously I can't demand, I don't own the water company, and I'm not one of those 5 seats, but I asked for that, and I realized that these smart meters are not cheap. It's gonna be a large expense for 5,800 connections or so, and that expense is gonna be passed on to the customer.
Right.
Obviously, I mean, that's how business works. So
That's
you
who will
can't,
pay for it, yeah.
you can't spend money in business and not make it back, and I understand that. And maybe it's something that can be phased in over time. But it seems as though, so the reason that I was given for the estimation is because they lost their employees, they quit or whatever it may have been, that read the meters. And so if this is going to be a continuing issue, we may need to see about a solution to that. And look, employees are not easy to get. I'm sure I'm preaching to the choir here. Employees are tough to first of all get, but then keep. So I can understand that. But our city, the city of Crowley, has a population of 47% poverty. Half of our population is considered poverty. To go from a $50 bill to like this lady tells me over and over again, she says she'll never forget that number, $298.99. That's tough on our citizens. That's tough. And so I'd like a serious solution on how we're going to go forward and prevent that from happening. So thank you.
Did any other commissioners got anything to say?
I'd just like to say that you have our attention. I want you to recognize that we appreciate y'all coming, and we'll see to the end that this gets addressed.
Thank y'all. Thank y'all very much.
Thank y'all for coming.
Really quick, thank you. This is a question for staff. Since our rule does not allow for estimations without a waiver or coming before the commission, does our rules also allow for penalties to a utility for violating that rule without notice?
I'd have to go back and look, Commissioner, but the
There
rules
is.
of water does have a penalty provision for violation. So we'd have to go through a citation process, but yes, we modeled it on the telecom rules, and I know there's violations, penalties built therein.
Thank you. And Mr. Mayor, the reason I asked that question is because I want to make sure that while LawCo has offered credits and refunds, this to me seems like an egregious mistake.
Right.
And something that should be taken seriously. So outside of their voluntary offer of credits, and I hope, and I think we're all in agreement here, that we will look at other ways to answer your question to ensure this doesn't happen. And you got my commitment along with my colleagues on that to do so. And I'll say I like even more because you have that great remarkable right there that I saw you writing on. And that tells me you're keeping a lot of good notes.
It's new. I'm trying to learn it. But listen, I appreciate that, and maybe that, and I'm not asking for fines to be imposed, but if the commission imposes fines, maybe those fines can be put towards the cost of some of these automated meters.
We might be able to help with that. I'm gonna let y'all try to figure it out amongst yourself first.
I appreciate that, yes.
And give everybody my phone number, okay?
Will do, thank you.
Mr. Chairman,
Thank y'all.
just a moment of personal privilege. I want to also thank you and your community for electing John Stefanski to your city court judgeship. He's going to do a great job.
We're excited about John.
And I look forward to seeing him in that role and at his investiture. I hope you're all there.
John's a great asset in our city. Thank you.
Thank you all very much.
Mr. Chairman, in a separate matter, as a personal privilege, real quick, 10 seconds. There was one former legislator I left off today, who's also in the audience. Representative Scott McKnight is here. I want to recognize Scott and embarrass him a little bit. And thank you for joining us at the LPSC. He's gonna be doing some work around this area, so thank you for joining us, Scott.
Hey, Scott. Well, we don't have a motion yet or a second, so Would
What's that?
Southwest folks want to handle it, or you want me to make?
What's that?
We don't have a motion or a second yet. Would the
Oh, all right, I'd
Southwest
like to make
folks?
a motion that we approve, Loco's.
Motion by
proposal.
Commissioner Francis. Any seconds?
I'll second.
Seconded by Commissioner Kusan. Any opposition? Hearing none, the matter is approved. Next item, please.
Exhibit number 24 is docket number U37969. This is CLECO's application for implementation of a change in rates and establishment of a new formula rate plan. It's a discussion and possible vote to retain United Professionals Company. On June 23rd of this year, CLECO filed the application seeking commission approval of an implementation of a change in rates to be effective July 1 of 2027, as well as establishing a new 2027 formula rate plan. In that notice of that filing, the company also indicated that another application will be filed with the commission shortly related to a large new data center customer, and said application will contain rate-making and deferral requests that will need to be evaluated in light of the commission's determinations in this proceeding. At the commission's January 2026 B&E, the commission retained UPC to assist staff in any dockets open seeking certification of new generation and/or transmission associated with these new types of customers. Per CLECO's rate application, it will need to be considered alongside its upcoming filing with the Commission's consideration of a new data center customer. As such, and based on UPC's general retention, staff solicited the company for a proposed bid associated with CLECO Power's instant request. Staff is seeking this solicitation pursuant to the Commission's general order dated November 10th, 2024. Based on staff solicitation, UPC submitted a proposed budget of $450,000 in fees and $5,000 in expenses for a total budget not to exceed of $455,000. This budget not only includes the analysis of CLECO's request, but it also contemplates a contested hearing as well as 3 annual reviews of CLECO's formula rate plan should the commission approve its implementation. Staff recommends that the commission retain UPC for $450,000 in fees and $5,000 in expenses for a total budget not to exceed of $455,000.
Go ahead. We have a step,
Motion
move
to.
to accept staff recommendation. Any seconds?
Second.
And we have a motion and a second to accept the staff recommendation on any opposition. Hearing none, the matter is approved. Move on to, I believe, 25.
Exhibit number 25 is docket number X38036. It's the Commission's notice of audit of Magnolia Water Utility Company's billing, customer service, and acquisition practices, as well as its compliance with other regulatory agencies. It's a discussion and possible vote to retain an outside consultant. Pursuant to the Commission's directive at the June B&E, staff issued RFP 2506 seeking an outside consultant and received 2 bids. They're both new qualified bidders as well. It's Eisner Advisory Group for $135,000 in fees and $2,500 in expenses for a total budget not to exceed of $137,500. Or Silver Point Consulting for $235,270 in fees and $19,200 in expenses for a total budget not to exceed of $254,470. Staff makes no recommendation as both bidders are qualified.
Move to accept the low bid of Eisner Advisory Group.
Second.
Seconded by Commissioner Lewis. Any opposition? Hearing none, the matter's approved. And the next item, please.
Exhibit number 26 is our undocketed reports, resolutions, and ratifications. We do have 3 items under this agenda item this month. The first is a report from the Commission's Utilities Division on jurisdictional water utilities water balances and unaccounted for water.
Okay. Who's going to carry that?
Mr. Marks.
Great.
So yeah, Donnie Marks, on behalf of staff. We gathered the information from all the water utilities on their water volume, the volume of gallons delivered, the unaccounted for water, and summarize all that with comments from the utilities. We have that all summarized.
Can we get a copy of it for each of the commissioners, please?
We can. We'll get.
Good, that'd be great.
We'll get that, and then we're going to continue to get those every quarter and monitor.
Perfect. That'd be great.
Yes.
Thank you very much. Next item on that, 26.
So the next item is discussion and possible vote to ratify votes cast by Chairman Skrmetta, acting as the Commission's representative on the Regional State Committee of the Southwest Power Pool.
I would like to interject that this took place before, when I was still serving in that capacity, and then since then, we've had a motion.
Correct.
For Mike to do it, but this was my last vote on SPP.
Correct. Yes, sir.
Okay.
I move to ratify the votes.
And second.
Second.
And I will abstain.
We also have,
We have to have a vote on it, so.
Any objections?
Any objections?
There's no objections.
No objection, it's ratified.
so there's also discussion and possible vote to ratify interventions of the commission and RTO related or other FERC energy regulatory proceedings. Staff recommends that the commission ratify actions taken in 13 proceedings over the last 2 months.
Move to ratify the FERC interventions. Any seconds? Seconded by Commissioner Francis. Any opposition? Hearing none, the matter is approved.
Exhibit 21.
But before she moves off of this, I know it's not announcements, but we failed to make an announcement at the beginning that I notified all of y'all that Tammy has the wrong name tag under her.
Right.
She is
got
now
changed.
our director of our regulatory and compliance division. So we combine transportation utilities. I want to make sure I acknowledge that.
Did you have to take a pay cut? I'm just checking, okay. All right, so we're moving on to, let's see.
Exhibit 27 is R 37871. This is the Commission's Louisiana Advanced Nuclear Exploration Program. It's a discussion and possible vote on final rule. It's at the request of the chair. The docket was initiated by a notice of proceeding filed on March 10th of this year pursuant to the directive at the February B&E. The notice was published in the Commission's official bulletin and several interventions were filed. Staff, attached to the notice, staff provided the proposed lane program and sought stakeholder comments. Staff reviewed all comments received and submitted its initial recommendation on July 21st of this year. Staff noted that the intent of the directive was clear and it specifically limited this rulemaking to establish a mechanism for IOUs and interested rural electric cooperatives to engage with specific nuclear vendors on potential technology. Staff also submitted for a second round of comments, and most feedback was in support of staff's initial recommendation, with only one minor clarification suggested by 1803. After consideration of all the parties' comments, staff filed its notice of final proposed rules on August 6th with the final rules attached. The final rules are mandatory for IOUs, however, they are voluntary for the electric cooperatives. Staff recommends that the Commission adopt the final rule filed into the record on August 6th of 2026.
Staff, Chair moves to accept staff recommendation. Any seconds?
Second.
Seconded by Commissioner Francis. Any opposition?
Yes, sir, Mr. Chairman, just briefly.
Sure.
While I support and I believe that we need to do nuclear research and development, I think this is an important time and topic that we should have. However, I do not think this is the appropriate time for us to put that responsibility on to Louisiana ratepayers with the rider. I would have loved for us to find federal dollars, state dollars, have even the IOUs contribute some of their own shareholder dollars to this research. So while I'm not opposed to the research and the Lane Initiative as directed and supported at the Commission, I just cannot support a rider on the residents of Louisiana to fund this research and development. So I'll have to object.
Okay.
Mr. Chairman, I also would like to echo the sentiment, not necessarily the final opinion, but my office has yet to kind of do a little bit deeper dive into this particular surcharge. I'm asking if you would entertain moving this vote to our September meeting and putting it first on the agenda, and then I'll absolutely have an opinion on the matter at that time.
Sure, we can move it to September, and I'd like to bring up that this is something we already do in a similar fashion for natural gas research. So it is, we're at a time where we have at least 4 new nuclear, micronuclear devices that have gone critical before July 4th. We have, I believe, 4 more that are going critical now. We're at the cusp of finding pathways for new nuclear technology. So we're really on the edge of this, and it puts Louisiana first in being able to develop not just the interrelationship with the use of them, but also in the potential of Louisiana being in the supply chain, workforce development, and manufacturing. So
I agree with your,
yeah, I said we're going to move it.
Well, I agree with your sentiment, but I also want to add that there are other opportunities for seed dollars that may be more apparent in the next couple of months, where this option, while I think it's an important step for the state of Louisiana to progress our discussions on nuclear, there may be other funding sources that make this negligible and, that do not impact the ratepayer to the extent that this does. So with that said, I'll have those discussions,
No,
over the next 4 weeks.
We'll move this to September, and I'd like to talk to you about if you know of anything.
Okay, yeah.
This is,
I'd like to ask Commissioner Kusan, if you don't find that money, you gonna vote for this then?
I'm a strong maybe.
yeah, there you go.
Okay, so for the record, Commissioner Scarmetto,
Defer.
you will withdraw your
I
motion.
withdraw my motion and defer it to September. Next item, please.
That is
Actually,
it.
that's it, right? Chair moves to adjourn. Any seconds? Seconded by
Francis.
Commissioner Francis. Any opposition? Hearing none, meeting's adjourned. Dylan?